Please call the list.
I'm for the petition.
Item number 1.
I'm for the board, my lord. Last occasion I couldn't, my lord, appear, my lord, because, my lord, we have missed the list, my lord. That is why, my lord, we could not appear, my lord. I tender my apology, my lord. কত লোক 1035? পারো তুমি।
Yes.
Your petitioner, my lord, participated in the recruitment process of 2020 conducted by the West Bengal Board of Primary Education. The notification of recruitment is at page, my lord, 342.
Whether the petitioners participated in the recruitment process?
Yes. They have participated, my lord, in the recruitment process. My lord, what has happened after getting the copy of the merit list?
Panel was prepared.
Panel was prepared, my lord. What has happened, my lord? Panel, in terms of the order of the Honorable Court, my lord, they have published the panel, my lord, on, my lord, 28 November 2022. Details of the candidates. Earlier, the panel was published on 17th March 2021.
Before that, panel was published
On 17th March 2020 and without details.
my lord, the order of the pursuant to the order of the division bench, when your lordship was, my lord, party to that, my lord, division bench, my lord, we published the panel. Your lordship asked us to, my lord, publish the panel in the wall of the West Bengal Board of Primary Education, as well as, my lord, every district primary office of the district primary school council and DI office. My lord, we have published. Therefore, my lord, they
When this publication was
Publication was made on 17th March 2021. Your
my lord, thereafter they filed SLP. SLP was dismissed. My lord, then they filed contempt before the division bench that in terms of your order of the division bench, we have not complied with. My lord, the contempt petition also dismissed that the division bench observed that the order was duly complied with. Now, my lord,
So what was the issue before the division?
issue, my lord, regarding, my lord,
What was the issue before the division bench?
issue was, my lord, the notification of 15th February 2021, when the panel was published, that notification was questioned with the learned single judge. Learned single judge was pleased to, my lord, stay the, my lord, entire, my lord, the notification as well as the appointment. My lord, against the order, both preferred an appeal before the division bench, where division bench said, my lord, that division bench asked the board to publish the panel merit list. My lord, we published the merit list. They said this is the merit list. No,
Show me the division bench order. Because if I was a party to that division bench, it may not be proper to hear this petition.
no.
Show me.
My lord.
If you have the copy of this order of the honorable
division
division
bench
bench.
order, my lord, that order is not annexed in the এই তো annex আছে তো না প্রতিভা মণ্ডল এটা
No, no, no.
that order is not annexed in the
Show me that order. Because
Babushala
today,
Mondol.
The select list or the merit list which was prepared based on the selection process of 2020 is under challenge
My lord,
on the ground of violation of reservation policy.
reservation policy.
Reservation policy. Now, previously there was an order passed by the honorable single bench, whereby the panel was
Not in the same issue, the other issue,
but in connection with the same selection process.
selection
But
process.
the panel was set aside.
Not panel was set aside.
What was the order of the single bench?
Order of the single bench was stay the operation of the publishing the panel.
Yes.
Against that order, we prefer the appeal.
Appeal. Then the division bench directed publish the panel.
Publish
and the
the
panel
merit
was
list.
given effect
Publish the merit list.
and give appointment.
My lord,
Now, the division bench directed publication of panel and
My lord.
giving appointment from the panel.
my lord,
Therefore, in terms of the order of the honorable division bench,
my lord,
panel was published
my lord.
and appointments have been given.
Made.
Today, petitioners are questioning that preparation of panel in connection with the selection process of 2020
My lord,
based on in connection 2020 based on violation of reservation policy.
my lord.
So let me see the order of
Order.
honorable division bench, and in order to find out whether it will be proper to hear this writ petition or not.
But the honorable division bench was pleased to pilot.
পার্টি ছিল যে ডিভিশন বেঞ্চ
Division bench হচ্ছে বাবুসালাম মণ্ডল।
সেখানে প্যানেলটা স্টে করেছিল জাস্টিস রাজশ্রী ভরদ্বাজ, সেটা ডিভিশন বেঞ্চ করলো, পারমিট করলো যে অ্যাপয়েন্টমেন্ট দাও।
যে অর্ডারের বেসিসে প্যানেলটা পাবলিশ করবে।
সেই অর্ডারটা ডিভিশন বেঞ্চ যেতে যাবে, যেহেতু উনি পার্টি ছিলেন ডিভিশন।
Produce this order of the division bench.
তাহলে কি অ্যাসাইন শুনবেন না?
হ্যাঁ মানে বলছি আমি এটা একবার
You also can take it up. Even then you will also can take
Subject
it.
to consideration of the order of the division bench.
But only
But your lawsuit is anticipating that probably your lawsuit would be a party to that. Even then, Malad, I think this is a different argument.
Very well. But in connection with the same selection process, let me decide the issue,
এটা
whether I will take it up or not.
নিয়ে আসি।
So show me that order of the division bench.
Malad,
at present, my lord,
Instead of
Actually,
entering into the merit of the case at the threshold, it should be proper so far this court is concerned to read the order of the division bench.
আমি আছে আমার কাছে কপিটা, কিন্তু
Unnecessarily, you will
whatever.
argue the matter whole hog, and thereafter I will decide, no, I will not hear it. That will not be
Malad,
proper.
that's why I'm saying your lawsuit. My submission would be your lawsuit. Even if your lawsuit is a party to that judgment, that will not affect this matter, merit of this.
But I want to see this, this order.
Then keep another day your lawsuit.
It is not part of the record.
No.
অ্যাভারমেন্ট ইজ দেয়ার।
Because my lord, I annexed the my lord list, but dated my lord 28 November 2022, published by the West Bengal Board of Primary Education, my lord, with all details of the merit listed candidates.
Well, I'll do one thing. Tomorrow morning, you hand up the copy of this division bench order to my officer,
এটা কি
Let me go
2020
through the
recruitment process
20
চলে?
and thereafter I will indicate when the copy এটাকে রাখা যায়। ফাঁকা থাকবে কবে?
অর্ডারটা অ্যানেক্স করোনি কেন? সব বলেছো গল্প, বলেছো কিন্তু
কোন order এটা বুঝতে পারছি।
একটা বাবুসালাম মন্ডল যারা ডিভিশন
দরকার কি আছে? ওরা
ওই অর্ডারটা বললো যে তুমি
আচ্ছা, ওই 12 নম্বর কোড,
12 নম্বর। আমার মনে হচ্ছে তুমি অ্যানেক্স করেছো, এই তো।
Malad, only one thing, Malad, let us be sure, Malad, I have gone through, but not very vividly. Malad, I believe there's only one point involved. No, that's not an annexure. Point involved in this writ petition. Otherwise, I have to file an affidavit. If only point is that if I find, my lord, that whether a reserve
Yes,
category candidate having got concession at the time of death can go to the recruitment process in the unreserved category on merit. Is it the only point?
এই অর্ডারটা অ্যানেক্স
Mr.
করেছো?
আছে।
মানে অর্ডার ইজ অ্যানেক্স।
Annex page my lord 406.
এই মাত্র তো একদিনই শেষ হয়ে যাবে। With that the only law point I will not.
আমি বলছি তো, আমি দেখেছি অর্ডারটা।
তুই ওটা
এত-
প্রতিভা মণ্ডল বলে দিলি তো, তখন আমি এই হয়ে গেল। At 406 my lord.
এটা কাকা দীপা নন্দী ভার্সেস বাবুসালাম মন্ডল।
হ্যাঁ বাবুসালামেরই।
And the Honorable Single Judge's order, my lord, which is at
Just
page,
before that,
just before that, which is at page, my lord, starts from
এটা
page,
কোন রিক্রুটমেন্ট প্রসেস নিয়ে
page 397.
2020 কি এসে গেল ডিফারেন্ট পয়েন্ট
এই 17 বসবে নাকি? বসেছিল। 17 বসতে
এটা তো আলটিমেটলি 16 এই ফিলিং আবার তো এইটাই 1200 কোথায় ভ্যাকেন্সি
এটা তো আলাদা না 1216 হ্যাঁ
এটা কি 2016 না
না
20
এটা 20
কমলের কি
কাউন্সিল
কাউন্সিল কোন কাউন্সিল পূর্ব মেদিনীপুর হ্যাঁ দিয়ে দিয়েছে আমার কি না
স্লিপ না ঠিক আছে
ওর তো পিছনে কেন অ্যাপয়েন্টমেন্ট ওরা তো এই মামলায় ওরা ছিল আনসাকসেসফুল হ্যাঁ তো তাহলে কেন বলতে হবে
এখানেও
এখন সারাজীবনই আনসাকসেসফুল থাকে 17 গিয়ে সাকসেসফুল হয়ে যায়
17 গিয়ে সাকসেসফুল
কিন্তু 17 শুনলে আমরা তা ভালো হবে গেলি ছবি
না না ওরা বলছে কমপ্লায়েন্স দেখবো তারপরে আমি তোকে ওর সাথে কালকে সাইটে চলে গেছি ওই জন্য হয়তো আজকে দেখতে হবে। এই পুরোনো লিস্টটা আছে ওটাকে রিভাইভ করে
চাকরি যাবে বলে
না চাকরি চলে গেল পুলিশ পুরো ঝামেলা করে গেছে পুলিশ কিন্তু পরে ফোন করেছে ওটা নিয়ে করেছে
না বলতে পারবো আমরা একটা ভালো শুনানি হয়নি তোরাও তাড়াহুড়ো করছিল আমরা শোনানোর দরকার ছিল না
শুনতে
বই আছেন তোর বই জানি তো জানি
আপনার বইটা ছিল আমার
আমাকে যে এই 17 বছর এই তো
চলবে না, শেষ করতে চাইছি, তুমি শেষ করে দিতে চাইছি। কমন বস করে আসবে হ্যাঁ, করুক তাহলে আমি ঘুরে আসি। এটা এখানে রাখুন, ছবি ধরে নিন আপনি, আপনি রাখুন, খুলতে পারবেন এটা? লক হয়ে গেলে, এই লক হয়ে গেলে গুরু লকের খোলার ব্যবস্থা করবো। মনে হয় দেখছি তুই বললি বাবু সালাম, বাবু সালাম আমি আছি। So, 15,000 candidate, more than
15,284
candidate have been appointed.
Now,
Appointed. Now, what about the writ petition? Because the Honorable Justice Mantha passed an order staying the public appointment and operation of this panel against
Justice Bharadwaj.
Bharadwaj, against which appeal was preferred.
That petition is dismissed.
That writ petition was dismissed. So therefore, pursuant to the order passed by the division bench, I was party to the division bench. The panel was given effect to upon publication of the panel. Now today, the same panel is being challenged on the basis of violation, on the allegation of violation of the reservation policy. Issue. Sorry.
Well, my surveying losses can take it as a different ground. It was not argued before the division bench.
Ground may be different, but the panel is same. The writ petition is heard in presence of the learned advocates representing the petitioners, district
May I
primary
take
school,
your losses, leave then.
district primary school council, district primary school councils, and West Bengal Board of Primary Education. Stop. In the writ petition, preparation of panel for appointment of assistant primary teachers relating to the year of 2020 is questioned on certain grounds. While hearing the parties, it appears that
এই ঘরটা ভালো ছিল।
the Honorable Division Bench with a order dated 4th March 2021 considered the same panel of 2020 and directed the West Bengal Board of Primary Education to publish the panel pursuant to which the panel was published, and consequently 15284 candidates were appointed. Stop. I was party to that, to the division bench, which considered the issue and passed order dated 4th March 2021. Stop. Today, the writ petition which is before me pertains to the same panel, validity of which has been questioned on certain grounds. Stop. Therefore, I find that it would not be proper, so far this court is concerned, to hear the writ petition. Stop. Next, accordingly, the writ petition stands released from the list and be placed before the Honorable the Chief Justice for appropriate order.
Obliged, madam.
But your lordship can, otherwise, my lord, the point is totally different.
Point is, issue is completely different, but the panel was given effect to pursuant to the order passed by the Honorable
Same
Division.
panel.
Same panel.
Same
That's true. my lord.
And an appointments were given. Justice Bharat
Now
passed
I
an
am
order
thinking-
staying the operation of the panel,
my lord,
against which appeal preferred. Appeal was allowed,
my lord,
and order was passed directing the board to
Board to
publish the panel.
publish the fact.
And as a result whereof 15,000 more
More
candidates
candidates
were
are
given
appointed.
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 Same panel is questioned before
Under
this
challenge.
court, under challenge. You are correct on different issue,
Different.
but it will not be proper on my part to
Right.
hear the this matter. If ultimately I find that no, the panel is the challenge is maintainable and challenge is appropriate, and then I have to set aside the panel. That will not be proper on my part. Try to appreciate.
No, no, my
I
lord.
predicament.
What is, yes, what is foreign from your lordship, my lord?
Obliged, madam.
Obliged, my lord. We are
Otherwise,
my
I am
lord.
ready to hear the matter.
No, no, no.
Yes, yes. Item number 2.
Item number 2, my lord, I am for respondent number 5 and 6. We have filed an application for vacating the injunction order, my lord.
And for the petitioner, writ petition can be heard and disposed of.
My lord, as per the, my lord, the application filed by respondent number 5 and 6 for vacating the injunction order, my lord. The petitioner was supposed to give an opposition, but they have not given it till date. So, my lord, if the matter could be heard. My lord, in this matter,
So
my
your
lord,
application is, you have filed an application for vacating an interim.
interim order, yes, my lord.
What interim order did this court pass?
My lord, on 22nd March 2022, the court passed order to restrain and not to
2nd March 2022.
22.
Just in.
Has passed restraining order not to give effect to the advertisement dated 18th October 2021.
Just a minute. May I assist your lordship? Just a minute. Application copy দিয়েছো?
আপনার order recorded আছে তো 16th September 2022. You have told before the court to will file an opposition.
Yes.
Yes, madam.
Now whether the post has not been filled up.
My lord, the post
why
has
you did
already
not
been filled
appear
up by.
in spite of service of notice? Pairadanga Samobhai Krishi Unnayan Samiti.
Yes, madam.
There was
My
an,
lord,
it is recorded in spite of service of notice upon the respondent 5, 6 and 7. You are representing 5, 6 and 7.
But only 5 and 6, my lord.
They
not
have
7.
chosen not to be represented before this court today. There was a notice issued.
Yes, my lord.
So now today on what ground you are seeking vacation of
My lord, the vacation was filed in the year 2022 itself, my lord.
Yes,
It was filed in the year 2022, my lord.
which was filed.
The vacating order, the vacating injunction order. Can 4, my lord, the vacating of the injunction order, the application was filed in the 2022, my lord.
Yes,
was
but
filed-
after, must be after the order was passed on
Yes,
22nd March.
after
2022.
the order
On
was
what
passed.
ground you are seeking vacation of the interim order?
My lord, first of all, my lord, the appointment of the petitioner was on a temporary basis. As per the order of appointment dated 28 July 2005, my lord, which is annexed in page 13 of this.
For that, the issue has to be heard.
Yes, my lord. Issue has to be
Issue
heard.
has to be heard. Now, there is an order, it is recorded in the order dated 22nd March 2022, that the assistant registrar has passed an order not to fill up the post.
My lord, the post is all
Have
the
you challenged whether that Pairadanga SKUS has challenged it?
But it has not been challenged, but my lord,
In
the
view of the submission made on behalf of the, just a minute. In addition, there to come to the second page, second paragraph of the order passed by this court. In addition, there too. June 2009, issued by the Assistant Registrar of the Cooperative Society Nodia, page 67 of the application, wherefrom it appears the Secretary of Pairadanga Samobai Krishi Unnayan Samiti Limited has been directed to refrain from recruiting a candidate on the post of Group D.
Yes, my lord. My lord, but the
Where is that
advertisement.
order, Mr. Bhattacharya?
My lord, page 67 of the application
Can-
for vacating, application for appropriate order.
Just a minute.
My lord, subsequent to the order, my lord, one indulgence, my lord. The order was passed on 29th June 2009. But subsequent to that, my lord, an appointment was made in the post of peon cum salesman. The appointment was made given to my lord, Mr. Subrata Sarkar on 16 July 2009.
Possibly
he's
my
already
learned friend is
working
not
there.
properly instructed. That person misappropriated money and for that he has been terminated.
No, there is no evidence as to such, but there an appointment
You
letter
were
was
not
issued.
properly instructed by your.
Kindly come to page 14, my lord.
Where is your application for appropriate order or
My lord, that is can 3 of 2022. It was filed on
yes, come to page 67 of that can.
serial bottom, my lord, copy forwarding. Number 2. Number 2 at the bottom. The sentence begins.
Just a minute. Yes, come to page 67. Read it. For one post of clerk, there was a person was deputed to be part of the selection process. Come to bottom, copy forwarded for information and necessary action. Serial number 2, read it.
Yes, my lord.
He is directed to refrain from recruitment to the post of Group D at present. This has a reference to this to his correspondence vide number so and so dated 30th March 2009. So have you challenged this?
But this was not challenged, my lord. The order appointment was made to my lord with respect to one Subrata Sarkar. He's working there as income salesman. And my lord, moreover,
So
the
unless until
advertisement,
you have not challenged based on which the interim order was passed by this court,
my lord, the
not to
interim
fill
order
up the
was,
post of Group D.
but the interim order was related to the, not to give effect to the advertisement dated 18th October 2021, my lord, and to keep a post vacant with respect to the advertisement dated 18th October 2021. But my lord,
This advertisement is the newspaper publication.
yes, but it is in page 68, my lord, of the
Yes.
can tree. 68.
Left hand side bottom.
No, there is nowhere written post of peon cum salesman, my lord. The post which the petitioner is alleging,
That will be considered in the writ petition pertaining to disciplinary proceeding. Today, the nature of post will not be considered by this court at this stage. In view of the fact that the writ petition is pending, try to appreciate the position that a person has been terminated. Your contention is that termination is correct in view of the fact that the petitioner was appointed on a temporary basis, on a casual basis. Therefore, petitioner does not have any right of permanence. So therefore, petitioner has been rightly terminated. Petitioner has got no right. Now that writ petition is pending.
pending, my lord.
Now that writ petition needs to be heard on merit.
Yes,
Now today, during pendency of this writ petition, if the vacancy which has caused due to termination of the petitioner is filled up and ultimately the writ petition is allowed, in that event, how the writ petitioner will be appointed or adjusted against that vacancy? That's why also the assistant registrar has also passed an order restraining the Samiti or society not to fill up the said post. Yes.
Now, my lord,
the post, it's not an identical post, my lord. They're
So
claiming-
therefore, the validity, the grounds
Instead of
which you are
post-
taking,
Yes,
that may be a germane ground at the time of hearing of the writ petition.
writ petition.
But if today I vacate the interim order, thereby implied permission would be there to fill up the post of Group D.
Nothing remains.
If the Group D post is filled up, what will be there? What will be remaining in the pending writ petition? That will be the filling up that post will make the writ petition infructuous. Have you filed affidavit in opposition to this writ petition?
My lord, affidavit in opposition has not been filed, my lord.
Then notice was served upon you, it did not appear in 2022. Then the affidavit in opposition you are not filing, and you are seeking that this interim order is to be vacated. Madam, how this can be countenanced?
But if I,
So let me fix up the
Affidavit.
writ petition for consideration
Yes,
for
ma'am.
final hearing after the affidavit to be filed by Pairadanga
Yes, ma'am.
SQS, and thereafter matter to be heard after vacation.
yes, my lord.
now let there be a very short time, short
After
period
the
to file.
vacation, my lord, 1 week after the vacation, my lord, we will file the opposition, or after that, my lord.
This is, my lord,
Your interim order is there.
yes, interim order is there, but his AG now. My lord, I am filing this affidavit of service which I have served copy upon all the
Yeah, yeah.
respondents. And
But they have also told to they have also, my lord, recorded as in the, it has been to file the opposition against can number 4. They have also not filed the
I
opposition.
have not filed, my writ petition is there.
Can number 4 is for vacating interim order.
Vacating interim order.
There's a direction by the bench,
By the court, my
coordinate
lord.
bench,
Yes, my lord. On
to
6th
file. I am disposing of this your can. I am disposing of your vacating application and fixing the writ petition for final
yes,
consideration
my lord.
on exchange of affidavits.
Affidavits, yes, my lord.
My lord, I am filing affidavit of service pursuant to your last order.
Just a minute. Let me find out this vacating application. Your vacating application is can 4 of
Can 4.
2020. Issue.
With your lordships kindly one matter called on.
Yes, yes. You are for the state. Today, the writ petition and your application has been disposed of.
No. That interim order was passed by your lordship.
That I know. It has not been disposed of.
No, not been disposed of. Oh, disposed of, my lord. Disposed of. By your lordship's order, 22nd March 2022.
Yes, disposed of. কি বলছিলাম? Writ petition and the connected application being can 4 of 2022 seeking vacation of interim order dated 22nd March 2022 passed by this court on an application being can 3 of 2022 are taken up for consideration in presence of the learned advocates representing the petitioner, comma, respondent number 5
5 and 6.
5 and 6 and the state respondents. Stop. Your name?
Priyakshi Banerjee, my lord.
Miss MS Meenakshi Banerjee, learned advocate.
Priyakshi.
Priyakshi. Miss Banerjee, learned advocate, representing respondent number 5 and 6.
5 and 6.
No, representing respondent number 5 and 6, representing
Respondent 6 died in 2020.
পায়রাডাঙ্গা সমবায় কৃষি উন্নয়ন সমিতি লিমিটেড, being respondent number 5 and 6.
My lord, 6 died in the year 2020.
5 and 6. Very well. পায়রাডাঙ্গা কৃষি উন্নয়ন সমিতি limited, being respondent number 5, submits that the petitioner, that the writ petitioner was appointed as
Peon cum salesman.
peon cum salesman in the said কৃষি উন্নয়ন সমিতি purely on temporary basis. Stop. Therefore, petitioner does not have any therefore writ petitioner does not have right of permanence in connection with his service, and keeping in view of the nature of appointment made in favor of the petitioner, the termination order passed against the petitioner may not be interfered with. Stop. It has further been submitted that due to the interim order passed by this court on
22nd March.
Wait.
Sorry, my lord.
On 22nd March 20, কি বলছিলাম? 22nd March 2022, the resultant vacancy which has been created due to termination of the writ petitioner is not being filled up, and the concerned Krishi Unnayan Samiti is suffering since the post could not be filled up. Stop. Next paragraph, on behalf of the said Krishi Unnayan Samiti, accordingly, prayer has been made to vacate the interim order dated 22nd March 2022, thereby permitting the respondent number 5 to fill up the said post of peon. Stop. Petitioner, writ petitioner is represented by learned advocate who has opposed the prayer of the respondent number 5. Upon drawing attention of this court to the order dated 29 June 2009, passed by the Assistant Register of Cooperative Societies, Nodia, whereby the respondent number 5 has been restrained from filling up the post of peon within bracket group D. Stop. It has also been submitted that the said order dated 29 June 2009, issued by the Assistant Register, till date has not been questioned by the respondent number 5. Next paragraph, while considering the prayer made on behalf of the respondent number 5, as well as the right of the petitioner during pendency of this writ, of the writ petition, whereby challenge has been thrown to the termination order issued against the writ petitioner. This court is required to consider the balance of convenience and inconvenience while deciding the prayer made on behalf of the respondent number 5 to vacate the interim order dated 22nd March 2022. Stop. If the application for vacating interim order is allowed, thereby if the application for is allowed and the said order dated 22nd March 2022 stands vacated, that will impliedly permit the respondent number 5 to fill up the post of peon within bracket group D during pendency of the connected writ petition. Stop. If the said if the writ petition is finally allowed, thereby permitting the petitioner to join the post of peon within bracket group D. In that event, such direction of resumption of duty by the petitioner will not be given effect, could not be given effect to, cannot be given effect to, since now, if prior to disposal of the writ petition, the said post of peon within bracket group D is filled up and third party right is accrued in favor of newly appointed candidate. Stop. Next paragraph. In view of aforesaid consideration, this court finds it apt to allow the interim order passed on 22nd March 2022 to continue till disposal of the writ petition. Stop. Accordingly, the writ petition, accordingly, the application for vacating interim order being can 4 of 2022 is dismissed. Stop. The learned advocate representing the respondent number 5 has prayed for extension of time to file affidavit in opposition. Stop. Let affidavit in opposition be filed within 1 week after ensuing puja vacation. Affidavit in reply to be filed, affidavit in reply if any. Affidavit in reply thereto if any be filed. Thereto if any be filed by the writ petitioner within 2 weeks thereafter.
Within a week.
Next paragraph, list the matter in under the heading, list the writ petition under the heading hearing group 5 cooperative society for disposal in the monthly combined list of December 2023.
Monthly combined list December, na?
নামটা একটু বলবেন নামটা বার অ্যাসোসিয়েশন
Room number 2 দেখবেন বলো তো দেখবেন
Item number 325.
Which I have for the respondent bank.
All of the petitions. One is the earlier occasion, my lord, the regarding, they raised the point regarding maintainability. My lord, maintainability, they did not raise regarding the maintainability at the time of admission of this petition. And the state as well as the society not yet file any opposition in respect of this writ petition. My lord, kindly, my lord, they relied, my lord, 2022 Supreme Court, my lord, paragraph 69. Paragraph 69C. But see, it must be consequently held.
Just
What-
a minute, just a minute. Yes, 69.
69C, it must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its action becoming amenable to the judicial review by a constitutional court, its employee would not have the right to invoke the power of the High Court conferred under Article 226 in respect of the matter relating to service, where they are not governed or controlled by a statutory provision. Kindly, but my lord, where they not govern the statutory provisions, kindly, my lord, the new act and rules, kindly see, my lord, 106. Or 106 of the rule.
এই রুলসটা দাও কোঅপারেটিভ সোসাইটি Just a minute.
দাদা
আপনি একটা দিয়েছেন রুলসটা দিন Rules দিয়েছি বন্ধু। তাহলে 106 method of recruitment, condition of service of the officers, employee of the cooperative society. Then this is a age of recruitment, sub rule 4. Then transfer and training, appointments, seniority, leave, conduct and discipline.
Method of recruitment and condition of service of the officers and employees of the cooperative society.
Cooperative society.
Since your bank is a credit structure entity, the service conditions of your service condition is not governed by 106. Come to section 134 B1A. Section of 2006 Act.
Yes.
Rule, not rule.
section.
Oh, please. Section 134 capital B.
The lordship, he doesn't has the amended copy.
Amended.
আমার কাছে।
134 capital B. Read.
National Bank means National Bank.
No. 134 capital B subsection 1 definitions.
This chapter 134B.
Yes, in this chapter unless
Context otherwise requires. Cooperative credit structure entity include the West Bengal State Cooperative Bank, District Central Cooperative Bank, Primary Agriculture Credit Cooperative Bank, and the West Bengal State Agriculture Rural Development Bank and Primary Cooperative Agriculture and Rural Development.
so therefore cooperative what are those what are those cooperative credit structure entity? The West Bengal State Cooperative Bank, District Central Cooperative Bank, and other authorities which are included under the definition clause of 134B1A. Now, your bank is a district central cooperative bank.
This is Central Cooperative Bank.
So therefore, it is not an other society. It is a cooperative credit structure entity. Now, come to section 134C. Next page.
Special provision applicable of the cooperative credit structure entity.
Yes, straightway come to 134 capital C subsection 2.
Cooperative credit
Read.
structure entities shall have autonomy to all the financial and internal administrative matter, including following areas: interest rate, borrowing and investment, loan, personal policy, internal control system.
So relevant is 134C2D. That is personnel policy, staffing, recruitment, posting, and compensation to staff. You follow?
Yes.
Now, if 2D is relevant, personnel policy, staffing, recruitment, posting, and compensation to staff, discipline and the
Yeah,
disciplinary issue is not coming under 134C2D. Therefore, the cooperative credit structure entity shall have autonomy in financial and internal administrative matters, including the following cases. Shall have autonomy, but not autonomy with regard to disciplinary issues relating to disciplinary proceedings or matters relating to discipline. Now, yes, bank.
Mala.
What are the rules which you follow while initiating proceedings against your staff or officers?
That is the service rules we are used to follow, my lord.
Which service rules?
West. West Bengal Services Rules 2000.
A proceeding has been initiated against the petitioner.
Yes, sir.
Have you been dismissed from service?
Not
Yes, he has been dismissed, but that
But
was not.
without going to the
Bolchi,
brief,
bolchi,
dismiss the service. Well, interim order says, well, without leave of the court cannot be dismissed.
My lord, without leave of the court, we cannot dismiss it, but it was not communicated and he was
Cannot. Decision has been taken, but it has not been given.
not been communicated.
But as per the
Yes,
interim
and he has been
order,
participating.
So which rule you have followed?
That was has been written. Just now I have seen, then I missed.
Proceeding has been initiated, a person has been terminated, and you do not know that which rule has been followed. Strange.
My lord, these are rules of 1987.
Show me that rule.
And from the memo of the charges, lordship would be able to find. May I hand up to your lordship? And these copies were served upon the petition.
Annexure P4 of the writ petition. Annexure
This
P4.
is the West Bengal Cooperative Society's rule, earlier rule, 83
okay.
Act. And
Before that.
before that,
And it was the act.
Act,
The proceedings were the long back. That's why it was followed.
83's Act and rules followed 87 rule.
Page.
Page 45 is the order of suspension, your lordship. The bottom paragraph states.
কোন রিটটার বলছিস?
47, the writ petition number is 18286. your lordship.
Page 45.
Your lordship, order of suspension dated 4th April 2008.
Yes,
And your lordship, the bottom paragraph.
bottom.
Page
paragraph.
47 it would be.
Just a minute. Sub-rule 16A of the appendix to chapter 6, rule 108 of the West Bengal Cooperative Service Rules 1987.
Societies.
Now, which the rules, in terms of which rules you have initiated and concluded the proceeding?
My lord, we have initiated that as per the memo, lordship, which I have handed over to your lordship. These are the memo of charges, my lord.
Yes, you address this court on violation of the rules.
Yes. Well, kindly
On what
see,
ground you have
my
question?
my lord point is, well, only point page 108. But the
There is an interim order which was passed in your favor not to pass the final order without a leave.
Yes, sir, lordship. And that is at page 60.
Justice Girish Chandra Gupta, as his
Yeah.
lordship then was.
Three matters, my lord, one Kollan Jyoti
On a pages on a page 63, my lord. 61, 60.
Yes, my lord.
But in this writ petition, I do not
No,
find
that
any
the
order.
main,
Petition, well, the three my lord, writ petition, one writ petition, my lord, on order dated 11th September 2008.
that is the 18286.
My writ petition number
18286.
698.
18698, এই দাও তো দেখি 18698 টা এখানে আছে।
And my lord, this was an annexure in the written petition 18286. That is at page 62.
Just a minute, yes. 11 September 2008.
2008.
Extension হয়েছে পরে
খেয়াল
whichever is earlier.
Whichever is earlier.
যেখানে extension আছে
This interim order was for a period of 30 till 30th June 2009. Now subsequently, whether the interim order was extended,
I believe
Well,
it's not.
litigation is pending as such, but not yet.
31st August 2009, it was extended. Interim order has expired.
But I have.
Justice Jayanta Kumar Vishwas, as his lordship then was, on order dated, video order dated 17th February 2010, has directed that the interim order extended on January 14, 2010, expired on February 11, 2010. Hence, there is no question of extending the already expired interim order. The petitioner is free to move the regular bench. So if the final order is passed,
The final not yet communicated.
then you have to challenge the final order.
Final order not yet communicated, but only my lord, point is.
Yes, obtain instruction whether it has been communicated or not.
My lord, before that, my lord, may I submit one thing?
Why two writ petitions at this stage?
Yes, Lordship, may I say, with due permission of my learned senior.
I am satisfied. Well, kindly.
Just a minute.
there are three applications. The first one is by challenging the suspension order. The second one was challenging memorandum of charges that is dated 18/7/2008, where the first challenge was suppressed.
Very well. The first
Ah.
writ petition was challenging the suspension.
Suspension order.
Second is challenging the charge sheet. And
Charge
the
sheet.
third is
And third is, my lord, there is a challenging another inquiry report.
inquiry report.
Inquiry report.
Only point, my lord.
Now, you have, whether you have communicated the order of
My
termination.
lord, candidly, I'm submitting, my lord. Just now, I also had a talk, my lord. We are searching for the long back file.
Because
Yes,
interim
searching.
order is not subsisting.
No, not subsisting, my lord. I have been instructed orally that it has been completed, but may or may not be communicated to the, he has participated on that very particular proceedings. That instruction I have.
But
my lord,
my point is.
Then I will grant liberty to the petitioner
to
to
challenge.
challenge the final
No,
order
my only point is, well, kindly pay.
of final order concluding the disciplinary proceedings if the final order is against the petitioner.
Lord.
Kindly, my lord, page 108. 108, my lord, in the writ petition, my lord.
Why so many writ petitions, one after another?
One, my lord, suspension, my lord, order. That, my lord, petitioner already retired. My lord, that writ petition already instructors because petitioner accepting the substantial allowance, my lord, up to, my lord, his date of retirement. As such, my lord, there has petition is already, my lord, has made an instructions. My lord, kindly see, my lord, only one writ petition, my lord, first item, my lord, is my point.
Tell me the writ petition number.
Writ petition, my lord, 18286. 18286, my lord, now, item number 1.
My lord, in my writ petition, annexure 15/16 is absent, my lord. Annexure 15, annexure 16 তো তোমার তাও নেই 14 এর পর আর নেই আমার কাছে কিছু 14 এর পর এসব কাজগুলো রয়েছে
18286.
18286.
Yes,
Page
page 100.
108.
108.
108.
Yes,
On last 3 lines, since the management of the bank is appointing.
just a minute, just a minute. This is, what is this document?
Document is the inquiry of the report of the inquiry officers. After completing the inquiry, since the management of the bank is appointing authority employer, has full liberty to take suitable action against Mohammed Nurul Basa.
Last paragraph. Therefore, on the basis of the above evidence.
Above evidence. Therefore, on the basis of the above evidence, last 3 lines, since the management of the bank
Is the
management
appointing
is appointing authority, employer has full liberty to take suitable action against Mohammed Nurul Basa as per provision of Rule 48F of the West Bengal Cooperative Societies Rule 1987. Kindly see, my lord, 48F of the rules.
then my lord he has to withdraw the second writ application.
To
Let me
determine,
hear it.
kindly, my lord,
It's
kindly see,
basic.
my lord, to determine F, my lord, to
48F
48
of the
F,
West Bengal
appoint.
Cooperative Service Rules 1987.
97. To appoint, discharge, or to dismiss or remove employees. My lord, only, my lord, dismiss or remove employees of the society. My lord, this is the punishment. My lord, they propose to give me this punishment.
Dismiss or remove him.
Dismiss or remove. But question is, my lord, after retirement, they can impose the punishment for dismiss or remove.
Why not? If the proceeding has been initiated before your
Yes,
retirement,
that is, my lord,
Why not?
I search, my lord, as far as, my lord, there's one Supreme Court judgment, the after removal, the dismissal or removal, my lord, does not arise.
after retirement,
After retirement.
if the proceeding is initiated.
Yes,
been
my lord,
initiated.
yes, my lord, proceeding was initiated.
Yes, that
In your case, proceeding has been initiated.
Yes, well, the Supreme Court also, my lord, this proceeding was initiated earlier.
That will be considered later on. Yes, you first obtain the instruction that what was the final order passed in connection with the disciplinary proceedings.
And on communicated or
today,
not.
The petitioner is not enjoying an interim order. If the final order is passed, you communicate this order, you place this order before this court on the next date. so that the court will consider the same and pass an order.
Mal.
And today, this court is considering 3 writ petitions, out of which one pertains to suspension. Since it has been submitted on behalf of the petitioner that this writ petition has become infractuous in view of the superannuation of the petitioner, let me dispose of the same being infractuous, and rest of the 2 writ petitions to be considered on a subsequent date after you apprise this court about the fate of the disciplinary proceeding which has been initiated against the petitioner.
And also, Malad, he communicated this decision or not? Malad,
Yes, সেটাই তো বলছে just, সেটাই বলছে। My lord, only one difficulty, my lord, may stand before your lordship, my lord. In the second read application, he is asking for that inquiry report was not been served. And in the another writ petition, he is challenging that particular inquiry report.
Yeah, after
That was, no, that was not that,
in the first writ petition relates to suspension.
suspension.
One writ petition, second writ petition relates to charge sheet.
Is it
Third writ petition
simultaneously?
is challenging, was filed challenging the inquiry.
Yes,
So what is the wrong in it?
no, my lord, there,
If inquiry report is faulty, then petitioner has got the right.
no, my lord, I'm not on that point, my lord. In one hand, in the writ application, that is the, I mean, the 18286, he has taken the stand that in spite of I did not get the inquiry report, I given reply to the report, my lord. And at the same time, he is making the same prayer that I am challenging that particular inquiry report we did not get in the earlier writ petition which was under challenge, my lord. That was the difficulty, my lord. And my lord, if the first writ application was placed, the second writ application
Which writ
not
petition
with
is relating to suspension? 10573.
10573.
In the service rules, cooperative service, West Bengal cooperative service rules of 1987, 87, there the proceedings relating to disciplinary proceedings.
Yes.
There, your lordship.
There.
Today also it is there, your lordship. In the 2011 rules also, the disciplinary proceedings is there in the method of recruitment and service, your lordship.
Then, Mr. Sureka,
Your lordship, that has been excluded. That the cooperative societies,
in case of cooperative society,
in other cooperative societies too, your lordship, kindly see.
which are coming under the ambit of rule 106.
134, your lordship,
No, no,
section
no.
134, the cooperative credit structure entities, for them the entire rules and regulations will not be applicable, which includes the disciplinary proceedings. And for other cooperative societies, on the last occasion, I had placed the division bench judgment, which Mr. Roy had placed, which had stated that subject to the terms and conditions between the parties, if that is absent, then these rules will be applicable for the other cooperative society. Your lordship, on the last occasion, I had
So
placed
therefore, 134C2D, there is, yes, 134C2D, in respect of cooperative credit structure entity,
Not
there is no
applicable.
rule relating
No
to
rules.
disciplinary
Your lordship,
issue.
it is, your lordship. Your lordship had a,
No, sorry,
your lordship was of the view that the personal policy does not include this, your lordship.
exactly.
Your lordship, but the section starts as a cooperative credit structure entity shall have autonomy
Now I have received the clue.
in all.
There are rules. In
In-
every matter, you take the point of maintainability. Now 1987 rules, 87 rules to uninhibited.
Your lordship, your lordship, only 2 minutes, your lordship. Just for our own satisfaction, your lordship. A cooperative
You will be
credit,
satisfied in some other matter, not.
your lordship, a cooperative credit structure entity shall have autonomy in all financial and administrative matters, your lordship. Internal administrative matters, including personal policy staffing, your lordship. This personal policy and staffing has been excluded under Rule 106, Your Lordship, which is not applicable to other cooperative societies. And in that appendix, the disciplinary proceeding has also been a part of that appendix, Your Lordship.
Only if that be so, then the permission from the ARCS office should not be still remain there. What my learned junior friend is submitting, if that be so, that stand is the right one, then the permission from the ARCS office should be taken by the CEO of the particular bank, should not remain still now.
For initiation of. proceedings.
Yes,
Your Lordship,
Yes.
we do not mandate, Your Lordship, the persons, the cooperative societies come before the ARCS, Your Lordship. Kindly ask them to show a rule.
Where is the order of suspension in your writ petition 10573?
my lord, order of suspension is at page
Dated,
24 in writ petition 10573.
Yes. Issue. তিনটে রিট পিটিশনের উপরে যে অর্ডারটা হচ্ছে অর্ডারটা হবে তার মধ্যে একটা ডিসপোজ হবে 3 রিট পিটিশনস আর টেকেন আপ ফর কনসিডারেশন ইন প্রেজেন্স অফ দ্য লার্নেড অ্যাডভোকেটস রিপ্রেজেন্টিং দ্য পিটিশনার কমা বীরভূম ডিস্ট্রিক্ট সেন্ট্রাল কোঅপারেটিভ ব্যাংক লিমিটেড and the respondent number 4. Stop. Mr. Kishore Mukherjee, learned advocate representing the petitioner, submits that out of these three writ petitions, the writ petition being WPA 10573 of 2008 relates to the suspension order dated 4th April 2008. Stop. It has further been submitted on behalf of the petitioner that in view of superannuation of the petitioner during pendency of the writ of the writ petition of the said writ petition, it has become during pendency of the said writ petition, comma, same has become infructuous. Stop. Next paragraph. Accordingly, the writ petition being WPA 10573 of 2008 is dismissed as infructuous. Stop. However, next paragraph. However, 2 other writ petitions relate to initiation of disciplinary proceeding against the petitioner. Stop. It has been submitted that there was an interim order passed by a coordinate bench on the writ petition being WPA 18698 of 2008.
আমাকে লাস্ট একটা পেজ দিও ফেসবুকে নেই আমার কাছে।
Your Lordship, kindly seize the division bench judgment forward. This is about the rule 108, Your Lordship, para 26.
হ্যাঁ, কি বলছিলাম? One eight six nine eight of where last on 3rd July 2009.
আমার একটাই রয়েছে। My lord is referring, Mr.
Just
আমি জানতে বিশ্বাস My lord, Wednesday next. But can it be after vacation, my lord? If
No,
your lordship so desire.
obtain instruction. 12th, Wednesday next, 11th October 2023.
Your Lordship, I have just handed over a judgment of the division bench, Your Lordship. This is for Rule 108. And this is also in regard to 1987 rules, Your Lordship. On the last occasion, Mr. Roy had placed these rules and Your Lordship had read this, Your Lordship, that it gives the autonomy to the cooperative societies to make a specific contract for their employer and employee, Your Lordship. In absence of a specific contract, if there is an absence that the employer and employee does not have a specific contract amongst themselves,
Whether
Your
that
Lordship,
judgment is in connection with the bank,
Your Lordship, this
credit
is-
structure entity or not?
it is in West Bengal State Cooperative, it is in regard to credit structure entity as defined in the 134B, Your Lordship. This is West Bengal State Cooperative Bank Limited. This is a division bench judgment, Your Lordship, which says that on the plain reading of such rule, it is evident that, Your Lordship, I have placed that judgment. Your Lordship, para 26, Your Lordship. Rule 108 of the said rules provided as follows, Your Lordship. This is 1987 rules, Your Lordship, 108. Conditions of service of the employees of cooperative societies. The conditions of service of employees of cooperative,
Paragraph.
Your Lordship, 26
Yes.
of this judgment, Your Lordship. Rule 108 of the said
Of
rule,
1987 rules.
1987 rules, Your Lordship.
Yes.
Conditions of service of the employees of cooperative societies. The condition of service of employees of cooperative societies shall, subject to the terms of specific contract enforceable by law and provisions of any law for the time being in force, be as enunciated in the appendix to this chapter. On a plain reading of such rule, it is evident that a cooperative society can contract out of the conditions of service as set out in the appendix referred to in that rule. In other words, the condition of service laid down under the appendix to the chapter 6 of the said rules would apply unless a cooperative society within the meaning of the said Act of 1983 has provided a separate set of conditions to service, Your Lordship. This autonomy has been given, Your Lordship. My point has always been, Your Lordship, in absence of a,
Just a minute.
Your Lordship. Thereafter also it has been explained further, Your Lordship. And this is also regard to dismissal of an employee. It is necessary to notice such questions as one of the arguments put forth by the writ petitioner is that so long as alternate conditions of service are not put into place,
Agreement ছাড়া হবে না বলছে।
Still, in an appropriate case, it will be.
Your Lordship, because they have conceded to Rule 108, Your Lordship, that is why this writ is applicable, maintainable, Your Lordship. If they would have maintained their service rule,
Because they have.
Your Lordship, as they have conceded to Rule 108 while taking disciplinary proceedings against this employee, Your Lordship, I also support that this rate is maintainable because St. Mary says if there is violation of a statutory provision, Your Lordship, when there is a public element,
Paragraph 69, subparagraph 3.
Your Lordship, when there is a public element, when the service condition is guided by a statutory provision, then in that case it will be maintainable. But if a cooperative society,
That 1987 rule is still in force.
no, Your Lordship, that has been repealed now.
Repealed.
At that point of time, it was, Your Lordship. Subsequently,
But
2006.
in this case, the proceeding was initiated in terms of 1987.
Yeah, Lordship, that is why I am also not objecting that this is not maintainable, Your Lordship. In cases where they have a service, Your Lordship, first we have to just look into that whether a private service contract is available or not. If it is not existing, Your Lordship, and as because this bank has already considered to Rule 108, this will be applicable because a proceeding has been initiated under a law, Your Lordship, and if the petitioner is able to demonstrate that
And
there has
this
been,
supports the observations made by the Supreme Court in
Your Lordship,
paragraph 69, subparagraph 3.
Your Lordship, this is what we have always been submitting, Your Lordship. If there is a condition guided, Your Lordship, that is always applicable, Your Lordship. Grateful, Your Lordship. Grateful.
11 September, 11 November.
Next. 18286 of 2009 and 10573. And Otana 18698. দাঁড়াও দেখে বলে দিচ্ছি। 18698 of 2008 টা dismissed হয়ে গেল। হ্যাঁ, 18698 of 2008, 18698 of 2008 is dismissed. Just a minute.
Dismiss ballot 10573.
Just a minute. তাই বলেছি না, ডিসমিস হলো 10573 of 2008, WPA 1, এটাই বলেছিলাম 10573 of 2008। আর দুটো ম্যাটার যেটা অ্যাডজার্ন হলো আমি বলে দিচ্ছি, 10573 তো 18286 of 2009, 18698 of 2008. These are to be heard on the next date,
My lord was pleased to fixed on 11th.
11, Wednesday next. ঠিকই বলেছিলাম, ও জিজ্ঞেস করছো কেন, কনফিউজ করে দাও। এটা রাখ, এটা লাগবে, এটা উনি আমাকে কি বলেছে, এটা দেখে রুলসটা এগুলো থাক, এগুলো আমার কাছে থাক। অর্ডার অফ সাসপেনশন, ওটা ওদের ফেরত দিয়ে দাও। You take back your rules.
My lord.
Number 6. Item number 6.
Serial number 6, my lord. Lord, serial number 6, my lord, Mr. Anand Banerjee is appearing for the Chamdani municipality. My lord, we require a brief, my lord, because we do not have the copy of the brief.
You hear the order? Wait. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, municipality is represented by learned advocate. Stop. Next paragraph. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost into the stop. Read petition stands dismissed. Intimator finish stands vacated. Urgent xerox certificate. Next. তাহলে নামটা দিও না, সেন্টেন্সটা কেটে দিও।
Item number 7.
Item number 7, I am appearing on behalf of the Calcutta Municipal Corporation.
At the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. However, Kolkata Municipal Corporation is represented by learned advocate. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioners have lost interest. Stop. Read petition stands dismissed. Intimator finish stands vacated. Urgent xerox certificate.
Grateful, ma'am.
Next.
Item number 8.
Item number 8, my lord, I'm laid by Mr. Parthopatim Royal Lordship. Lordship, it is a old matter and somehow Lordship, the brief is not traceable. If your Lordship kindly permit me to go through the record once so we can serve notice to the petitioner, and if your Lordship kindly allow me to appear the matter next month in this Lordship.
But this matter was taken up on 22nd September
Yes, Lordship,
2020.
on that day, it was not in
It
our
was
knowledge.
fixed for
Lordship.
hearing subsequent on
Lordship.
29.
In that day,
No one appeared. How long these matters will continue?
last opportunity.
Run in the
Lordship.
list.
Last opportunity, Lordship.
And the petitioner
Issue.
received the contact with us.
At the time of call, accommodation has been paid for on behalf of the petitioner. Stop. However, no one is representing the respondents to do. Stop. Next paragraph. Acceding to the request made on behalf of the petitioners, hearing of this matter stands adjourned in order to enable the learned advocate for the petitioners to obtain instructions. Stop. Next paragraph lists the matter under the same heading for further consideration on 12th October 2023. Stop. Next paragraph. However, it is made clear if on the adjourned date, however, it is made clear on the adjourned date, no further however, it is made clear on the next date, no further adjournment shall be granted.
Lordship, may I go to the record once? So, Lordship.
Yes. Have inspection of the record.
Item number 9. But I am for the Kolkata City Corporation.
At the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. However, Kolkata Municipal Corporation is represented by learned advocates. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioners have lost into. Stop. Writ petition stands dismissed. Intimatum fini stands vacated. Urging xerox certificate copy. Application. Application তো একটাই সাবস্টিটিউশন ছিল, সেটা ডিসপোজ অফ হয়ে গেছে। দেখি দেখতে হবে তো, ওরকম ভাবে লিস্টিং করলে হবে। PS 1410 অনেক আগে ডিসপোজ অফ হয়ে গেছে। Application for substitution dispose of হয়ে গেছে। পুরো substitution allow. Next.
Item number 10.
I'm for Kolkata Municipal Corporation led by Mr. Bihani.
Where is Mr. Bihani?
Lordship, he is on legs, Lordship.
Has he come to court?
Yes, yes, Lordship.
Yeah. At the time of call, no one appears for the petitioners and no accommodation is paid for. However, Kolkata Municipal Corporation is represented by learned advocates. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioners have lost interest. Stop. Writ petition stands dismissed. Intimatum fini stands vacated. Urgent xerox certificate copy. Next.
Grateful.
Item number 11.
At the time of call, no one appears for the petitioners and no accommodation is prayed for. Stop. However, Kolkata Municipal Corporation is represented by learned advocate. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioners have lost interest. Stop. Writ petition stands dismissed. Intima definition stands vacated. Urgent xerox with copy. Next. Yeah. Item number 12.
But I'm for the Howrah Municipal Corporation. I'm led by Mr. Shondiban Banerjee in this matter.
Where is Mr. Banerjee?
In courtroom number 24, madam.
Courtroom number
24.
11. At the time of call, no one appears for the petitioners and no accommodation is prayed for. Stop. However, Howrah Municipal Corporation is represented by learned advocate. Stop. Next paragraph. Same situation prevailed on 22nd September 2023. Stop. It appears petitioners have lost interest. Stop. Writ petition stands dismissed. Intima definition stands vacated. Urgent xerox certificate copy.
Okay.
Next.
Lord, sir, I am for the municipal.
Item number 13. At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. However, Rajpur Sonarpur municipality is represented by learned advocate. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Intima definition stands vacated. Urgent xerox certificate copy. Next. Item number 14. At the time of call, no one appears for the petitioners and no accommodation is paid for stop. However, Kolkata Municipal Corporation is represented by learned advocate. Stop. Next paragraph. Same situation prevailed on 22nd September 2023. Stop. It appears petitioners have lost interest. Stop. Writ petition stands dismissed. Interim order of finish stands vacated. Application, comma, if any pending, comma, also stands dismissed. Urgent Xerox certificate copy. Next.
Item number 15.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order of finish stands vacated. Urgent Xerox certificate copy. Next.
Item number 16.
At the time of call, no one appears for the petitioners and no accommodation is paid for. Same situation prevailed on 22nd September 2023. Stop. It appears petitioners have lost interest. Of writ petition stands dismissed. Interim order finish stands vacated. Urgent Xerox certificate copy. Next.
Item number 17.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Intima refinis stands vacated. Urged in Xerox server copy. Next.
Item number 18, well, I am for the petitioner in this matter. my lord. Change view, my lord. Two representation was made by the my lord petitioner. First, my lord, against my lord. Against my lord passage, narrow passage, my lord, plan has been sanctioned. Secondly, my lord, unauthorized construction, violation of deviation of plan, my lord. My lord, the earlier the petition moved, my lord, before this honorable court, my lord, the ordinance being, my lord, pass the order, my lord, stay order, as there is a deviation of the plan, my lord. And affidavit of the opposition also direction was made by the honorable single bench earlier. But affidavit filed for it. Where they hang it? কাটকে দিচ্ছে কি করে?
So you are enjoying an interim order.
Yes. No making a further construction. And interim order also continue.
Now, problem is this, video order dated 26 November 2015. Learned advocate for the petitioner was granted leave to amend the cost title and and incorporate Howrah Municipal Corporation in place of Bali Municipality as respondent. Now, in the meantime, there is a demerger. Bali Municipality has now Bali Municipality's function after demerger. Now, in view of this fact that you have to serve notice upon the Bali Municipality and amend the cost title again.
Yes, my lord. It is a change we my lord. The problem, my lord.
Now, Bali Municipality is functioning. At one point of time, Bali Municipality merged with Howrah Municipal Corporation. Now, therefore, there was a direction by this court for amendment of the cost title. Now, there is a demerger, and in view of demerging, Bali Municipality should be made party respondents.
So leave be granted to
Issue.
amend the cost title.
Writ petition is taken up for consideration in presence of the learned advocate representing the petitioners. Stop. Next paragraph, on perusal of the records, it appears video order dated 26 November 2015. A coordinate bench granted leave to the learned advocate for the petitioners to amend the cost title and add and substitute Howrah Municipal Corporation and the authorities of Howrah Municipal Corporation in place of Bali Municipality and its authorities. Such order was passed since there was a merger of Bali Municipality with Howrah Municipal Corporation. Stop. Subsequently, Bali Municipality has been separated from Howrah Municipal Corporation by way of demerger. Stop. Accordingly, Bali Municipality and its authorities are required to be added as party respondents, required to be added as additional respondents on further amendment of the cost title of the writ petition. Stop. Let amendment of the cost title. Let amendment of the cost title be made by in course of this day. Let amendment of the cost title be made by the learned advocate representing the petitioners in course of this day. Stop. After such amendment is carried out, pursuant to the leave granted by this court today, learned advocate for the petitioners are directed to serve notice upon newly added Bali Municipality and its authorities within 10 days thereafter.
Madam Oil Manager is
Stop.
also is appearing for the Bali Municipality. Copy we have on the
The learned advocate for the petitioners shall also be at liberty to serve notice upon the learned advocate who usually represents Bali Municipality, in addition to the service which is to be made upon the Bali Municipality. Stop. 10 days বললাম, তাই তো? List the writ petition under the same heading in the monthly under the same heading on 20th November 2023 for further consideration. Next.
item number 19.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim finish stands vacated. Application, if any pending, also stands dismissed. Urgent xerox certificate copy. Next.
Item number 20.
My lord, I am appearing for Bali municipality led by Mr. Arun Banerjee.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. However, Bali municipality is represented by learned advocate. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim finish stands vacated. Urgent xerox certificate copy. Next.
Item number 21.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim finish stands vacated. Urgent xerox certificate copy. Next.
Item number 22.
I am for Southern municipality led by Mr. Bihani.
At the time of call, no one appears for the petitioners and no accommodation is prayed for. However, South Domdom municipality is represented by learned advocate. Stop. It appears petitioners have lost interest of writ petition stands dismissed, interim order finished stands vacated. Urgent Xerox certificate copy.
Lordship, kindly my affidavit in opposition
Yes,
kept in
fine.
record.
Add a line. South Domdom municipality is represented by learned advocate who has filed affidavit in opposition to the writ petition and the same is taken on record.
Grateful, Lords.
Item number 23. At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order finished stands vacated. Urgent Xerox certificate copy. Next. Item number 24. At the time of call, no one appears for the petitioners and no accommodation is prayed for. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order finished stands vacated. Urgent Xerox certificate copy. Next. Item number 25. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Intimata finish stands vacated. Urgent Xerox certificate copy. Next.
Item number 26.
In this matter, but I am appearing for the petitioner. I pray for time, my lord.
But this was, this is the second occasion. Matter was taken up.
But I
On
missed
22nd
I missed
September.
the list on the last occasion, my lord. Today it has come to my notice.
What is the matter about?
Related to regularization of the services of the petitioners in the municipality. They are still
Which
working.
municipality?
Jiaganj, Azimganj municipality.
You are seeking regularization on what basis?
Because not they are serving since long back.
Whether your case has been considered by the director of local bodies?
No, not yet.
Not yet. Still you are working. Still petitioners are working.
Yes.
When they were appointed, show me the appointment letter.
But I don't have the brief today. I think, my lord, I have stated in paragraph.
First for the state, Mohammad Yamin Ali appeared. He is no more. Now subsequently, Mr. Shadhan Haldar appeared. So therefore, you serve notice upon Mr. Shadhan Haldar. He appears for the state and also serve upon Jiaganj, Azimganj municipality. Issue.
Well, let it be after vacation, my lord.
At the time of call, accommodation has been prayed for on behalf of the petitioners. Stop. However, no one is representing the respondents today. Stop. Next paragraph, the learned advocate representing the petitioners has prayed, learned advocate representing the petitioners is directed to serve notice upon the respondents or the learned advocates representing the respondents, enclosing copy of the order passed by this court today by 11th October 2023 or by 13th October 2023 and file affidavit of service on the adjourned date. Stop. Next paragraph, list the matter under the same heading for further consideration on 20th November 2023. Next.
Item number 27.
27, Lordship, I beg to appear on behalf of the petitioner, my lord. May I pray for one-day accommodation, my lord.
Why?
It's an old brief, my lord. I requested client to visit me. He is here today. My lord, any date.
No instruction.
And in any.
Affidavits are complete.
After yes, everything will complete. After the vacation, lordship takes.
No.
And I am ready, my lord. Next.
Next, you will get 1 week time. Issue. At the time of call, accommodation has been prayed for on behalf of the petitioner. Stop. Kolkata Municipal Corporation is represented by learned advocate. Stop. Next paragraph, acceding to the request made on behalf of the petitioner, hearing of this matter stands adjourned till 12th October 2023 in order to enable the learned advocate for the petitioner to obtain instructions. Stop.
যেমন রিপ্লাই কি আছে আমি তো আপনার রিপ্লাইটা দিচ্ছি না
Next paragraph, however, it is made clear that no further adjournment shall be granted on the next day.
তোমার আছে
Next.
দেখে নিচ্ছি এই নিন। ওই একসঙ্গে দিয়ে দিচ্ছি।
12th. Item number 28.
তুমি করবে নাকি এটা আছে তাও যায় হ্যাঁ আমি বাড়ির ছিল হ্যাঁ না না নিরঞ্জন হালদার ও প্রদীপ্ত সেটা আমি ভিড়টা খুঁজে পাইনি আমি নিরঞ্জন হালদার মনে করছি বিদ্যা
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Same situation prevailed on stop. You are appearing for the corporation?
no no
So Baraypur municipal. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Intimate of finish stands vacated. Urgent Xerox certificate copy. Next.
Item number 29.
29, I beg to appear on behalf of the petitioner.
But in
My lord,
29 my lord, I appear for the respondent, but I could not my lord, find out my the brief. I'm just requesting my learned friend if he can provide my lord the
Upon payment of cost.
Can you kindly fix it on 12th?
Issue. At the time of call, accommodation has been paid for by Mr. Ghosh, learned advocate representing Kolkata Municipal Corporation. Stop. However, petitioner is represented by learned advocate who has not seriously opposed the prayer for adjournment as made on behalf of the corporation. Stop. Next paragraph. List the matter under the same heading for further consideration on 12th 12th October 2023.
Deeply.
Next.
Lordship. এটা খুব মামলা
এই খাতা সহজে টুকু লিখে দিলাম
Item number 30. Lordship.
মামলা থেকে কি দেখছি
Petitioner may never appear after filing this case.
You are appearing for? You are appearing for?
This one was 6.
You are for the state, you are for the corporation.
Lordship, both the matter filing opposition and supplementary. Lordship, kindly grant to the supplementary. All this clear before the corporation.
So you are filing affidavit in opposition and supplementary affidavit.
Supplementary myself. This one was 6. Supplementary copy.
Why supplementary affidavit? Was there any leave granted to file supplementary affidavit?
No, as because Lordship kindly grant to the order of the Justice Sumit Pal. Lordship, the petitioner moved an application, another application.
Writ petitioner moved another application. But what for you are filing supplementary affidavit today? Was there any leave granted?
Because after one was that, court person has settled the matter and passed out order in favor of the respondent. Lordship kindly answer the.
In favor of respondent number 6.
Lordship.
So that order of the corporation you have brought on record by filing supplementary, by affirming supplementary. Yes, Mr. Mukherjee, do you have any objection if the supplementary?
Only statement is there. Actually, in my copy, there is no order. Full copy ta din.
কি কপি চাইছে
আছে?
মেন্টারি কপি আছে
Well, I do not raise any objection.
What is the matter about?
Well, there are three things involved. One is assessment, second is mutation, the third is illegal construction.
Now, whether the mutation has been made in favor of the respondent number
That
6.
they are saying that it has been done. If your lordship sees the supplementary affidavit and
Assessment, mutation and
illegal construction.
three things are clubbed together.
Yes, your lordship sees the.
Very well, since petitioner is not appearing, there is no need to enter into the merit of this issue.
Is never available. Earlier,
Issue. A writ petition is taken up for consideration in presence of the learned advocates representing the Kolkata Municipal Corporation, respondent number 6 and state respondents. Stop. However, no one is representing the petitioner and no accommodation is paid for. Stop. So far, representation on behalf of the petitioner is concerned, same situation prevailed on 26. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Next paragraph. However, the learned advocate representing the respondent number 6 has filed affidavit in opposition to this writ petition and one supplementary affidavit. Both are taken on record. Stop. The writ petition stands dismissed. Interim order finish stands vacated. Urgent xerox certificate.
31.
So far, representation on behalf of the writ petition is concerned. Same situation. Stop. The petitioner has lost interest.
31 I am appearing for Bali municipality.
31.
Yes, my lord. Led by Mr. Arun Banerjee.
Respondent number 6.
7 থেকে 12 আছেন উনি আর আমরা বাকি দুটো বাকি প্রথমটা 6 নম্বর
At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, Bali municipality is represented by learned advocate. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Intimate if any stands vacated. Application if any pending also stands dismissed. Urgent xerox certificate copy.
Lordship, 32,
No,
33,
no,
Lordship,
beyond.
no, Lordship. Kindly take it up next day, Lordship. I
Matter
have
has
got
become
some
contentious,
assignment.
It's covered by your lordship's order. So your lordship,
Kindly-
we will not
Any mentioning on the original side? Original side, listed matters, new motions, item number 1.
My lord, I appear for the petition in this matter, my lord. My lord, may I indicate that service upon the private respondents, some of the respondents is incomplete, my lord.
Why?
My lord, the track report has come as insufficient address, my lord. May I hand over a copy? May I file my affidavit, service? If your lordship kindly sees page 11, service tech.
Sir, affidavit of competency.
My lord, the service is there. Kindly see page 11, my lord. The track reports, my lord. Insufficient address. Then kindly turn over to page 13. Insufficient address, my lord, at the bottom. Thereafter, my lord, 15. And my lord, page 17.
One is out for delivery, page
No,
11.
my lord, that is when it has come to me. Kindly see, my lord, at the bottom, Hatkhola SO, it item returned insufficient address. The envelopes have come back to me, my lord. And my lord, one more thing, my lord, my client has
So application, recalling application.
Yes, my lord.
Why it has been filed after 2069 days delay?
Yes, my lord. This is a repetition of in the year of
You are
2006.
applying
my
for
lord.
the corporation. Yes.
It's a
Yes, your case.
Madam, led by Mr. Choudhury.
I was told service is not complete. Some people have died.
Why delay? 2059 days. Recalling application. Mr. Choudhury, what is happening now?
Let us also learn the law.
What to say, Vinod?
Yes.
It's long delay.
What is the explanation?
To the extent. May I?
Yes. Yes.
I learned friend us. Me at a tight spot. My lord, only difficulty is that I will not be in a position to challenge this valuation before the statutory authority also because of this long gap of time. My lord, if my learned friend agrees, I know it's too much to ask for. If my learned friend agrees, then the lordship permits me to approach the tribunal.
Where is the order? Which is in respect of which you are praying for recalling?
That was, my lord,
At page
page 154.
Yes, July 2016.
This is 2016. And we are challenging a valuation.
And filed on 19 September 2023.
Yes.
Excellent.
The explanation, my lord, is that I didn't know my advocate had died.
What is the matter about in the writ petition?
We challenged an annual valuation and lot subsequent demand and attachment by the corporation. And
whether the attachment order has been given effect to?
Valuation was the subject matter of challenge in the writ petition. Now, my lord, dues today would be around to the tune of 5 crores. The property is 11 Chorongi Lane. They took on lease,
Not 36.
not 36. They took on lease
5 kathas of land on a very royal sum of 460 rupees to be paid per month to the lessor, constructed a 4-storied building. Utilizing the 4-storied building for the purpose of renting it out to the various tenants and collecting rent. Now the notice of assessment proposal was given. Nobody responded to it. It was decided long time back. What they did, they filed a suit before the city civil court. There is not a single line in the entire bunch about the city civil court case.
I have no idea.
City civil court.
কোথায়
I'll give you. Here is the thing. See, city civil court says the KMC is at liberty to take appropriate steps against the owner of the premises to realize the arrear dues. That is not under challenge in any proceedings. We are now, since the dues are not paid, we have proceeded. We have taken steps 217, 219, 221. That 221 he cannot challenge unless he revives his writ petition. So this is a circuitous way to file an application to revive a writ petition dismissed 3 years, 4 years back. And now, so that he gets a locus to challenge that 221 notice.
Yes,
this is the sum and substance
the attachment
of the game plan.
There's no game plan.
Of course, yes.
The attachment order is
There is some.
It's a simple restoration application with a lot of delay. If the explanation finds favor, it will be allowed. If not, it will be dismissed. There's no
A cost
game.
of 1,000 J with the legal aid services authority. Let the writ petition be heard on merit upon payment of cost. Or do you want to file any affidavit to this?
I think I should, because these documents which I am referring to are not there on record. At least I get a chance if I file an affidavit.
So that can be to the main writ petition. Let him file.
No, since there is a delay of issue. Application being GA 1 of 2023 is for recall of the order dated 20th July 2016.
As a guest house.
So what is, I don't understand what is wrong with
there's
giving a
no-
lease, using it as a guest house. You don't become a criminal for these reasons.
On the connected
Why?
writ petition. Stop. However, there is a delay of 2586 days in preparing the recalling application, for which condonation has been asked, has been sought for by presenting a comprehensive application. Stop. Next paragraph, Mr. Mukherjee, learned advocate representing Kolkata Municipal Corporation, has prayed for opportunity to file affidavit in opposition to this application. Stop. Let affidavit in opposition to this application be filed within two weeks from date. Stop. Reply there, reply thereto if any be filed within 1 week after ensuing puja vacation. Stop. List the matter for further consideration under the heading adjourned motion on
But giving 2 weeks to file affidavit.
yes.
Before vacation.
2 weeks, 1 week after vacation, the petitioner will file it.
Your lordship kindly gives me 3 weeks. I'll give him a copy by 19. Let him give a reply thereto by a week, and let the matter appear 2 weeks.
3 weeks it will take within vacation. Today we are on 5th, 12, 9. Yes.
That will take us to 18th or 19th.
Affidavit in opposition within 1 week after ensuing puja vacation. Reply thereto if any be filed within 1 week thereafter. Stop. List the matter for list the matter under the heading adjourned motion on 6 December 2020.
Great.
Great.
My lord, I am representing respondent number 1, the state.
Yes, enter your appearance.
You have to.
Before my learned friend starts, my lord, an affidavit had been filed by my learned friend on the previous occasion. That's I'm told previous week. Only seeking your lordship's kind indulgence to file a counter pleading to that. I don't want to Lord, pray for stalling of the hearing, but may I be permitted to file a counter pleading because
But you have filed an
my supplementary affidavit. He has filed an affidavit in opposition, taking certain positions regarding the mortgage, which are completely in my reciprocal submission required denial. And these are questions of fact. So I will be required to bring that on record. I leave it to your lordship, Lord. If your lordship wants, Lord, I can file it on the next day and your lordship can continue hearing thereafter. Or my lord can proceed today, my lord, giving me the liberty to file it if.
Yes, your lordship. This writ petition, your lordship, on the last occasion, your lordship, I moved it, your lordship, and after your lordship hearing me, your lordship was of the opinion that there whether your lordship there was a gross delay, your lordship, in approaching the court, and in the meantime, if there any third party interest has already been created in favor of any third party. So on the last occasion, your lordship, I have shown your lordship that I have challenged your lordship in this writ petition two things. One, the order of the regularization of unauthorized construction which has been done by the Kolkata Municipal Corporation, and the second part, your lordship, that there was an unauthorized construction over the roof in which the learned advocate for the Kolkata Municipal Corporation, your lordship, has said, your lordship, that regarding the unauthorized construction on the roof, your lordship, that appropriate steps have already been taken by issuing a notice under section 400. So we were concentrating.
under section 4.
There was unauthorized construction part by part. So far the ground floor is concerned, corporation approved that.
That is car parking space.
Car parking
And
space.
unauthorized construction plus change of. Subsequent
Last change of
use. Car parking space converted into office, etc. Subsequently, it was further discovered, in respect of first one, there was a corporation has passed an order that in future you will not do anything. That was the condition. Thereafter, also they converted they made another construction on a portion of the roof, and that was also detected, and subsequently notice was issued. Perhaps no one appeared, and the order was passed.
demolition order was passed.
This petition is pending.
No, that has been pulled out. That has been whether the demolition order has been given effect to. Yes, that.
This case is pending. So
But that demolition order in connection with the construction at the roof, that is not an issue.
In respect of car parking.
Is also an issue.
That is not an issue in this writ petition.
That is also an issue.
This order relates to car parking as well as construction too.
To both. I have challenged the both. Only one thing, your lordship, they have not communicated me the copy of the order of the demolition on the roof, your lordship. That particular order has not been communicated, despite we have given a notice under RTI Act.
During pendency of this proceeding, so we could not give it. There was no occasion.
During pendency of which
writ
proceedings, that order of demolition was passed.
Just it was passed. Nothing done after thereafter.
So therefore, implementation of the order of demolition in connection with the construction which has been made at the roof cannot be delved into in this writ petition.
He has challenged both the
Construction has been questioned.
Now, the person who has suffered the demolition order, they have to pay for an appeal before the trial.
Building trial. That's yes.
Now, your lordship, on the last occasion, I have shown that what they have done, they have just converted, your lordship, the car parking space on the ground floor. They have covered the entirety, and your lordship, they are converted into an office space. And on the last occasion, your lordship posed me a question that whether you have a right in the car parking space. So I have, your lordship, placed those particular deeds in which, your lordship, they have already transferred before, your lordship, the regularization, your lordship, the car parking space in my favor. So that particular deed also I have shown. Thereafter, your lordship, I have shown your lordship that various representations were made in the year 2012, 2013 and thereafter. And finally, we have come to know that an order has been passed on 5th of April 2012. Now, a delay point, your lordship, has not been taken by the respondent number 5 and 6 in the affidavit in opposition. So delay point has been taken only by the Kolkata Municipal Corporation. So my contention, your lordship, was that this particular order dated 5th April 2012 was never communicated to me by the Kolkata Municipal Corporation. So I had no knowledge. I had actually, your lordship, that this particular order was not, your lordship, in my hands to challenge it. So what happens, your lordship, from 2012 onwards, when I was giving the representation, Kolkata Municipal Corporation was not doing it. In 2017,
One of the flat owners.
I am, your lordship, the
Association.
I am the association as well as, your lordship, the office holders, your lordship, in that particular building, because this entire building is, your lordship, is fully commercial building. We are the unit holders. Respondent numbers 1 to 10. Petitioners number 1 to 10. So sorry.
So all are office accommodations.
All our office accommodation. We purchased, your lordship, this car parking space, and those car parking space, your lordship, was already mentioned in the deed of conveyance as well as, your lordship, the schedule. May I only show
But
one?
your contention is the major point is delay. Now your contention is this, that when this order was passed in the year 2012, at that point of time, this order was not communicated to you.
Never communicated.
Where you have stated this?
Yes, your lordship, kindly says.
5th April 2012 order was not communicated to you.
This clearly, your lordship, has not mentioned that this was not communicated. But your lordship, in the subsequent affidavit in reply, or your lordship, in the affidavit in reply, your lordship, to the supplementary affidavit, I have clearly stated that the Calcutta Municipal Corporation never actually communicated this order to me. It's not the case of the Calcutta Municipal Corporation also. I'll show the affidavit in opposition. They are merely saying it's a delay. So therefore, I have delayed delay, your lordship, extreme delay. I have approached this honorable court. That's why this particular writ petition should be dismissed. There is no explanation that why this illegal order should be sustained after the order passed by the Honorable Calcutta High Court in Ghanshyam Das's judgment, which clearly says,
at the risk of being reprimanded, only one thing: affidavits have been exchanged. I am requesting my learned friend, if he is not aware of the contents of the affidavit, he can place it, my lord, before your lordship. 2 or 3 submissions contrary to what is there in the affidavit are being made. Point of delay has been raised by me. They have come into the property long after the order of 2012. So there is no question of communicating it to them. These are points taken in the affidavit.
So may I
I'm requesting my learned friend to kindly place the affidavit. Otherwise, what happens is the honorable court would trust, my lord, what counsel submitted the bar. I'm requesting him kindly to stick to the affidavit.
In 2012, when this order was passed, they were not
None of them was there.
They were not
Then
there.
subsequently, they came, saw everything, purchased offices, was enjoying. 5 years later, they have taken open car parking spaces. They have purchased open car parking spaces thereafter by deeds. They have acquiesced to the entire thing. Now acquiescence is a bar. Even in a statutory right, acquiescence is a bar. Waiver is a bar. These are things that have been taken in the affidavit. He has dealt with it. When he places it at the bar without showing those portions, my lord, the honorable court will trust counsel to be making correct submissions, at least on records.
Yes, Mr. Sengupta.
Lordship, kindly come to page 29 once.
The facts, as Mr. Banerjee
Yes, your lordship. Kindly take once, your lordship. May your lordship deal Mr. Banerjee's submission when he says something.
You are not there. You have subsequently purchased the property, knowing fully well the position at the ground floor.
Should kindly take page 29 once.
20?
Page 29.
Of the writ petition?
Of the writ petition. And Mr. Banerjee says something, your lordship, is actually should be page 29, your lordship, the first deed.
It is of 2011.
I'm grateful. And this is a registered document, 6 September 2011. There, that means, your lordship, this particular deed has been executed prior to the order. May I reply one by one of Mr. Banerjee's submission?
No, I'm not trying to intimidate him, or I can't. It's not within my jurisdiction. I'm simply requesting my learned friend, whenever he places things, to place facts. The deed he's showing, again, he's not showing the schedule that he has purchased an open car parking space despite knowing that there has been
This is
conversion.
of 2011, not
I will
2012.
I will show your lordship the relevant pleadings regarding this also. Let him finish in his own way. My humble request to him is, if he goes by any fact, let him place it from the document and the affidavit. Otherwise, my lord, we might be inadvertently misleading your lordship. We'll be not doing justice.
Yes, yes. Now, may I show your lordship the exact same thing which Mr. Banerjee has said? This is page 29. Your lordship, kindly come to page 45. The schedule.
Just a minute.
Yes.
Page 45.
Page 45.
Yes, schedule.
All that the unit being office number 2, measuring 583 square feet of super built up area on the 3rd floor of the building constructed at the said premises, described in the first schedule hereinafter written and shown red border in the plan A annex here 2, together with one open car parking space in the ground floor of the building.
Open car parking. Yes.
Yes, in the ground floor.
Yes.
So at that particular ground floor has been covered.
No. It's my.
If this particular ground floor, your lordship, has been covered, I'm sure I've taken instruction. This ground
Then
floor
why
has been
it is
covered.
written open?
No, open because this is not covered car parking. Your lordship, kindly appreciate one thing. In multi-storied building, your lordship, Mr. Banerjee, kindly allow me. I'll
great
place one by one document. I
Great
will not disturb you.
With great respect, my lord, with great respect. The difficulty is, if we are on facts, if we don't agree on what are facts, then my lord, the dispute will never be solved. Let my learned friend satisfy himself from the materials. I am saying with responsibility that the portion that has been allowed to be converted is the covered car parking space underneath the building. The portions which all the flat owners contemporaneously and subsequently with their eyes open purchased by registered deeds are open car parking spaces which have been allocated. So it is not his case in the deed also that after purchasing his car parking space, it got converted into something else. He purchased an open car parking space which he is very much enjoying
Not
today.
underneath the.
Not underneath the building
The
That's
ground floor of the
of the building.
first story.
Yes.
Yes, because that's your lordship. If
Ground floor of G+1.
G+,
G plus 1, it has to be this has to be under the ground.
There is
First
Mr.
floor.
Banerjee saying that Subway is trying to address this court on that had there been a car parking space underneath the building, in that event it will be covered car parking space, not open.
I'm great with this.
Open car parking space means it is not underneath the building.
No, with deepest respect to your lordship, that is not the case. And why Mr. Banerjee is saying, I am saying so. What he has done, he has, your lordship, converted those particular open space into a elevated car parking. And what he's trying to say, I have purchased those particular car parking. No, it's the ground floor, open ground floor, your lordship.
So
Those particular car parking has been sold.
Did you purchase open car parking or covered car parking?
Lordship, may I indicate? Nowadays,
No,
there is.
first answer the query of the court.
It's not open to the sky. It's open means it's not covered.
Wall.
Mr. Banerjee, kindly allow me. Yes, I'm grateful. Calcutta Municipal Corporation, at least is in fair, your lordship is submitting, because there cannot be a open car parking space open to sky, because those are driveways. And what he has done, his client has done, he has converted, your lordship, he has converted those driveways into a elevated car parking spaces. And now he is
These are
saying
also open car parking space.
these are all open to sky, not on the ground floor. If I say, your lordship, we have purchased flats in our buildings. Those are all open car parking space on the ground floor, because Calcutta Municipal Corporation building rule says there has to be a.
So you purchased a car parking space underneath the building.
Underneath the building. That's why it's on the ground floor.
Something different.
No, that's an
His deed
interpretation
says
of.
something different. He interprets his deed. His deed says
I'll say, your
open
lordship,
Well, my lord,
car parking space. He knows better
learned
Calcutta
friend-
Municipal Corporation laws than me.
my
Your
learned
lordship,
friend,
it's.
where is the question of the law coming in? These are facts.
These are your documents, brother.
Exactly, I'm showing the documents. I'm showing the documents that those particular car
Or,
parking.
my lord, is changing the case in the pleading, my lord.
Lordship, in my entire life I have not done. Entire life I will not do.
Entire life, I am unaware of this occasion. There is a deed which you have annexed where everything shows that you have purchased open car parking space. Open means open to
Is
sky.
there any site plan which is annexed to this?
No.
Generally a site plan is annexed to the deed.
Yes, your lordship. Building plan, your lordship, is there. I
Show
can
me.
show the building plan. Just give me. Those are all car parking space, your lordship, on the ground.
Generally, in general parlance, it is used open means open to sky. And the covered car parking space means it is underneath the building or in the basement.
Let him produce the conveyance. There is a plan with marking A, which is not part of this
Lordship,
copy.
may I show your lordship the building sanction plan?
Let him show what he has first purchased.
Because your lordship, it is not. He is trying to, your lordship, just what happens, your lordship, if it is covered car parking, it's just like a garage with 4 corners.
No, in the multi-storied building, covered car parking space does not mean it's like a garage, which is surrounded by three sides of the garage is you will find a wall, brick wall.
Yes,
In multi-storied building, covered car parking space means it is underneath the building.
Yes, your lordship. Then, your lordship, may I show your lordship the building sanction plan where, your lordship, the car parking spaces are there.
And if it is open, then it means open to sky.
Then it will be mentioned in the building sanction plan.
Yes, show me from
Yes,
the
your
building sanction plan. There might be an indication whether you have purchased the open car parking space or covered car parking space.
Lordship, kindly take page 222. Page 222. Otherwise, there is no requirement of conversion of those particular car parking space, with deepest respect. Page 222. It will help me. Corporation will help me. Corporation is always with the truth.
Yes, I have understood. You always stand for the truth. I am convinced.
So page 222.
You are trying to mean that the car parking space should be within the chamber. If it is a open car, it is covered car parking. That is not the concept in multi-story building.
But in the building rules, your lordship, I'll show it depends on the height of your lordship of the flat.
Rule never speaks of wall for a car parking space.
Sir, let me conclude it. I may be wrong. You'll correct it and win the matter, please.
It's swayed by Mr. Banerjee's comments. You are addressing this code.
Lordship, kindly see the lordship.
Therefore, address this code.
Page 222.
Yes,
car parking.
this is the sanction plan.
Yes.
This is the plan
Yes.
which is attached, which is annexed to your deed.
Yes, your lordship. No, not an. This is a building sanction plan.
His deed plan has not been disclosed. It's a part of his deed. It has not been annexed.
So are you trying to whether he will rely upon this building sanction plan?
Yes, your lordship. Building sanction plan which has been converted.
Lord, I'm sorry, my lord, I interjected, my lord. I'll let my learned friend finish in his own way. I'm so sorry that I interject.
Yes.
Lordship, kindly see the
If I
bottom
unfold
portion.
it, it will be very difficult to fold the same.
Yes.
Yes. Yes.
You kindly see, your lordship, the left hand side bottom.
You have junior, I don't have junior. Nowadays. Yes.
একটু পেছনে করে দেওয়া
Yes, bottom left hand side.
Left hand side, your lordship, kindly sees Golapupur square lane, then ground floor plan.
Yes.
And just above that, there is a zigzag 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. These are the car parking which has been converted. And apart from that, your lordship kindly see the
According
entire
to
building
these
plan.
car parkings,
Yes,
these car parking spaces were open car parking or covered?
covered car parking. Above that, your lordship, there is your
Where is the
lordship.
driveway? Show me. Where is the driveway? Generally, open car parking spaces are allotted opposite the driveway. At one side of the driveway, you will find the multi-story building, and just opposite side, you will find the open car parking spaces.
Lordship kindly sees the left-hand side and the right-hand side, and the bottom, these are the driveways from where your lordship, this particular vehicle.
Where? It's a front elevation.
Yes,
Then
your
where is
lordship.
the driveway?
In the ground floor plan, your lordship, it's shown A, D, C. These are the driveways from where your lordship, the vehicle will go out. Left-hand side,
D, right?
A.
Driveways.
Then lordship, exactly right-hand side, B. A, then an extreme right, B. Then your lordship, left-hand side, top C. Below your lordship, D. These are the driveways of the building.
Mr. Banerjee, from this sanction plan, it appears that opposite, on the opposite side of the driveway, there is no car parking space allotted.
The MLCP, the multi-level car parking was permitted in lieu of conversion, and with
No, no.
the MLCP,
So far, the car parking spaces which have been allotted from number 1 to 12, 1 to 12, all it appears underneath the building.
yes,
Underneath the building.
yes, there is no difficulty.
And surrounding this this ground floor plan,
Is a
mind
driveway,
that there is a
white driveway is there.
But at the opposite side of the opposite side of the driveway,
There are no
there is
triangles
car
to show that there is allotment of car parking spaces in the original sanction plan. There are no triangles. Lordship sees those triangles which are there, that are there at the ground floor level of the building. This indicates that the original sanction was granted with car parking
I will
space.
direct the corporation to apprise this court whether, apart from car parking spaces which have been allotted or which have been there as per the original plan, which is underneath the building, any other car parking spaces have been permitted as per the original sanction plan, which is not underneath the building but within the compound. Situation will be clear.
And what happened, your lordship, what they have done, may I just indicate the facts, what they have done, in those particular driveways, they have, your lordship, constructed those particular, your lordship, the elevated car parkings. Now for
Driveways
that,
have been converted into elevated
yes,
car parking.
now they have done. When I objected to that, they filed a suit before the city civil court and get an order of injunction. Now what they are trying to do, they have converted this particular car parking space into an office, and they are saying your car parking is there and you take those.
At the elevated car parking space.
I'm grateful.
Which is which is on the driveway.
On the driveway.
For this to be borne out by facts, my lord, he is required to, my lord, produce his conveyance. His conveyance has a plan. It's marked in red. It's mentioned in the schedule. The plan is missing.
Of the sanction plan, it does not appear that apart from the car parking spaces which have been allotted underneath the building, any car parking space.
In
has
the
been
original sanction,
provided-
yes.
Provided at the opposite side of the drive.
Yes, in the original sanction plan, the entire car parking spaces that were provided were
Underneath the-
covered car parking spaces. In the present scenario, the car parking spaces that are there are open car parking spaces which have been purchased. And there has been an order permitting an MLCP to come in, a multi-level car parking to come in order to make good the change or the orientation. The flat owners are complaining against that. 2 or 3 aspects your lordship will consider. The first aspect would be whether they can complain. 1, 2, whether this is an unauthorized construction.
Why they cannot complain?
If there is a deed, now it is now the Supreme Court has elevated it estoppel by deed to a large extent. Even in respect of statutory rights, it has been taken to be a conscious and voluntary relinquishment of one's right, even a statutory right. There is no public benefit over here. These are individual car parking spaces to which they claim alleged title. Now, my lord, if your lordship looks at their deed, if there are disclaimers in the deed which will take away that right, then they cannot turn around from those deed and come and challenge it today. Now, my lord knows this law has developed a bit. So once Mr. Sengupta places, my lord, the facts,
Very well, let him place his fact.
Yes,
I am only requesting him again, my lord, being
Tell Mr. Banerjee, please take your seat. Yes, I
to stick, my lord, only to the records.
yes. I'll show the deeds first. Lordship, at least I have shown your lordship that at least on 6th of September 2011, your lordship, there is a deed which clearly shows your lordship that there is a car parking space, your lordship, in the ground floor of the building. Lordship kindly sees page 45. All that the office being office space number 2,
with a impugned order,
yes, your lordship.
this car parking space, open multi-level car parking spaces, which have been sanctioned by the Kolkata Municipal Corporation, that is elevated car parking space, that has been allowed by the corporation by issuing this impugned order in the year 2012.
Lordship, I could not get it, your lordship. This is only a conversion order.
Conversion has been allowed.
Yes,
Conversion of the ground floor into an office space.
yes, your lordship. And even your lordship, in none of the pleadings, either by the Kolkata Municipal Corporation or by them, your lordship, they have shown.
But that order, which is dated 2012, which is under challenge,
Yes,
with regard to granting permission to use other spaces, open space within the compound in order to convert the same into car parking space, the order is silent on this.
order is silent. Is only the conversion has been allowed,
Ground floor
And-
conversion.
and they admitted that there is an unauthorized construction, and that unauthorized construction has been converted into.
Unless and until any sanction is granted, Mr. Mitru, unless and until any sanction is granted, whether the multi-level car parking space or elevated car parking space can be made. Because your original plan shows that there are allotment of car parking space underneath the building. So there was no other space which could have been utilized as car parking, open car parking space. So how the private respondent utilized the open car parking space or open space and converted the same into open car parking space?
This matter, so far I gather completely been ordered to them.
And that too, it is being submitted that elevated car parking space has been made.
I'm telling.
Last for that. Last. So that order is at page 276. Page 276 starts with charges for retention of unauthorized construction under section 400 subsection 1 of the KMC Act 1980. So there is a lordship admitted position that there was an unauthorized construction there for which the retention has been allowed. Kolkata Municipal Corporation, re 39A, Jorapuku Square Lane, Ward 25, Borough 4. Charges for retention of unauthorized construction under section 400 within bracket 1 of the KMC Act 1980. This sketch and order of special officer building dated 5/4/2012 and duly verified by such and such dated 5/4/2000 in this respect. Then the sanction fees has been given. Now page 277 onwards, your lordship, there is an order.
Order, right?
And your lordship kindly sees the effective portion is at page 278. That no order for demolition is hereby passed in respect of the unauthorized construction and conversion subject to comply with the following precondition within 30 days from the date of the communication of the order. These conditions are: 1. Person responsible must produce a structural certificate certified by KMC empaneled structural engineer, certifying the structure is stable, safe and sound, and the materials used are as per the latest edition of the National Building Code of India. They must furnish an affidavit declaring on oath that they will not make any construction whatsoever in the impugned premises without the prior permission of the Kolkata Municipal Corporation Authority. And 3, they will pay the necessary retention and conversion charges of the KMC, including penalty of 11 numbers shortfall of car parking as calculated by the department in a separate sheet of a paper altered and supplied with the final order. On non-compliance of the either of the condition with the above stated specified period, the KMC authority shall demolish the same at the cost and the risk of the personal responsible. So from the order, it is very clear that there was no permission granted to them regarding the construction of the elevated car parking space or to cover up the entire ground driveway.
Mr. Banerjee, how the open space has been converted into elevated car parking space? Because that is not provided in the original sanction plan.
The original sanction plan does not speak of that. There is, I'll tell your lordship, in between the mandatory open spaces and other spaces that are available, subject to the stipulation of the deeds. I'll take your lordship through the deeds in my own way and show that this is permissible from the civil point of view.
In the deed, there may be, it may have been provided. And that provision has been made in favor of the purchaser. But how this open space have been converted into elevated car parking space?
No,
it is not there in the original sanction plan.
No, corporations 400 subsection 1 order.
Because this order is silent in Mr. Sengupta.
Yes, yes.
Is
This is a subsection 1 order.
Open car parking space.
Yes. Now this subsection 1, my lord, they see the entirety of the premises and they take a decision of whether to permit the impugned constructions to remain or not. The entirety of the premises comprises a huge open area, including a covered area. Now, the portions of the covered area were permitted to be brought into our office space. Entire building is commercial and comprises office spaces. The portions that were underneath the ground building were since relocated outside. They purchased it with their eyes open. I'll come to their aspect later because my lord's question is on the statutory authority. Yes, my lord is.
They purchased rightly or wrongly, knowing fully well. I am not on this. That there is a out of 3 conditions. 1 condition is this: there should not be further
Unauthorized construction. So therefore, there was a first.
It appears from your submission that, and also on perusal of the original sanction plan, that underneath the building car parking space has been provided.
Yes.
As contains in the original sanction plan.
My lord.
Now it emanates from your submission that the car parking spaces, the covered car parking space, according to you, has been converted into office space. Now the cars are being parked at the elevated open car parking space.
They have been parked.
Elevated open car parking space has been constructed without a nod of the Kolkata Municipal Corporation.
Now, my lord, this is something about which I'll have to take instructions regarding what exactly happened. But I can tell your lordship. I have also
order of demolition. You have done the mischief. You have done the mischief.
Subsequent demolition order, whether regarding car parking space, any order has been passed on.
Now, the understanding that
you obtain instructions.
Yes.
The understanding that is there in these cases always is whether you can provide for alternative car parking accommodation within your building. Now, if I have been able to provide for that, my lord, that is the way to compensate, my lord, for the purpose of change of orientation. That's all my submissions that are. My lord is right when my lord says that, my lord, in the original sanction plan, there was no sanction of car parking spaces on the open parts of the building. But then subsequently they have been relocated and this has continued.
Yes.
Now, may your lordship also clarify the situation whether your lordship these driveways, your lordship can be converted. Your lordship kindly take page 33, where your lordship in the deed, the car parking space your lordship has been defined, as well as the common facilities. Page 33.
Page 32.
Yes, your lordship. Page 33, clause 1.4. Clause 1.4.
Page 32.
33, your lordship.
This is part of your
This
deed.
is part of your lordship, the deed dated 6 September 2011.
Yes.
Car parking space means open car parking space lying at the ground floor of the building at the premises Saket Sri. Now, your lordship kindly sees 1.5 common facilities. Common facilities shall include lift, corridor, hallways, straightways, landing, water reservoir, tube well, pump room, passageways, driveways. What he has done, he has actually converted those particular common spaces into the elevated car parking. And now he is saying, I have purchased the property, or rather the car parking in those particular elevated, which is actually constructed on the driveway.
Yes.
Now, moreover, your lordship can take page 34 also. Clause number 1.12. (1.12) says the said unit and the properties appertaining thereto shall mean that the said unit being office space number 2 measuring 583 square feet super built up area more or less on the third floor of the building constructed on premises number 39A Jorapukur Square Lane, Kolkata, named as Saket Street, together with one car parking space in the ground floor, together with the undivided proportionate share in the land comprised in the same premises attributable thereto, regarding the other amenities and facilities.
So therefore, the deed says it is in the ground floor.
Is in the ground floor. And the four corners of the deed, nowhere it shows, your lordship, that I have purchased something, your lordship, is in the driveway as a common space. Why should I purchase it? Common space, your lordship, is actually belongs to all the flat owners or the unit holders of that particular building. Why should I go and purchase something which is a common space? Now, apart from this particular deed, lordship kindly sees the next deed, that is at page 51. Page 51, your lordship, again, this is a conveyance dated 26th August 2011.
Yes.
This is again, your lordship, before your lordship, the order has been passed. And your lordship, the same, your lordship can see, your lordship, the schedule of the deed that is at page 68. Page 68, your lordship, together with one car parking space in the ground floor. And these particular properties, your lordship, car parking, your lordship, nowadays is very expensive. I have purchased this for valuable consideration.
Mr. Banerjee, one aspect also is very striking, that these deeds are dated 2011. Now the order was passed in the month of April 2012. Now in 2011, together with open car parking space in the ground floor. Now you are trying to demonstrate before this court that this car parking space denotes a space which is opposite the main building, and it is on the driveway.
No, beyond
Now-
the frustum of the building, beyond the structure, beyond the structure of the.
Building, it is just opposite side on the driveway. Now, if that be so, the original sanction plan, which I have perused just now, which does not contain any car parking space, open car parking space, which are situated at the opposite side of the driveway. Now, the only car parking spaces have been provided underneath the building and at the ground floor. Now, these conveyance deeds were executed in 2011. The position remains as per the original sanction plan. The car parking space must be within the underneath the building, and as per the sanction plan. So at that point of time, when these deeds were executed, what is the scope of allotting a car parking space which is outside the precincts of the building?
That's because the open car parking spaces have been taken allotment of. That is there in the premises. One thing is the legality of it, if your lordship takes it from the point of view of the original sanction plan. My lord is absolutely correct, my lord. As an officer of court, I will not try to twist facts in order to, my lord, assist my client or for that matter anyone. My lord is perfectly correct when my lord says that in the original sanction building plan, the car parking spaces which were sanctioned as triangles are underneath the building. Therefore, that is the sanctioned car parking space where you can give for parking of cars. At the relevant point of time, upon negotiations, and these materials are there on record, that's why I am trying to, I am wishing within myself that Mr. Sengupta finishes his tirade so that I can come up with my defense as soon as possible. There are materials on record showing that each of the flat owners, including those who have come in later, have purchased open car parking spaces delineated as such and are parking it there.
But these two deeds show rather that these are dated 2011.
Yes.
When this open car parking space or elevated open car parking space was not there.
My lord, if the kindly, my lord, in order to alleviate this,
Original sanction plan does not contain or does not permit the private respondents to allot open.
There are two aspects. One is what was provided in the car parking in the original plan.
Of car parking space,
yes,
which is indicated in the schedule of the deed dated 2011,
my lords,
does show that this
must be pertaining to the
underneath the building.
Now, my lord, to that, my lord, my reaction is, if your lordship kindly looks at his conveyances, if he can bring his conveyances in original, show your lordship, there is a map in red color which shows where the car parking is. My instructions are, and I have taken responsibility in taking these instructions. Legality, whereof my lord will decide.
What is the date of the sanction plan?
Kindly see.
Date of the sanction plan, once your lordship, is in 2008, and subsequently the completion. Building sanction plan dated 22nd January 2008, and completion certificate they have obtained on 30th May 2011.
Dated 20th.
Lordship, this is 22nd of January 2008.
And completion certificate.
Completion certificate 30th May 2011.
30th May 2011.
11.
These are deeds prior to the completion certificate, at least at
No.
page 74.
No, page 29, 6 September 2011.
Yes, yes, please. What I'm trying to show is contemporaneously they chose an open car parking space that has been granted to them by conveyance. That is grantable by conveyance. Now, my lord, I will have to answer to your lordship as to whether by non-showing of that in the corporation's original sanction plan, the grant itself becomes bad. And whether someone who is
Mr. Sengupta, you address me. I understand the position.
Yes, Your
Address me. Only thing is this: there's a delay.
Yes,
2012 order you have challenged in 2017.
Lordship.
Now, if there is a creation of third-party interest, if that is found to be fatal, in that event there will be a difficulty in invoking my jurisdiction. So therefore, you address on this based on the affidavit affirmed by the.
because I brought on record a registered instrument of mortgage. There's a registered instrument of mortgage of a lawful structure.
Lordship. May Your Lordship shows Your Lordship, I have shown page
Yes,
74.
you place it according to your own.
Yes.
That is one of.
I got my point, Your Lordship. That is the only point, Your Lordship, which I am worried today regarding the delay. And I have an explanation to that, Your Lordship, that why this particular writ petition could not be filed at that point of time.
Yes.
And page 74, Your Lordship, the other deed, Your Lordship, which was executed on 9th of February 2011,
Just
that
page 74.
page 74.
Ninth February 2011.
Lordship, page 74, Your Lordship, 9th February 2011. Deeds are same, languages are same, schedule is also same, where Your Lordship, the car parking is mentioned on the ground floor. Now, Your Lordship, kindly take page 95. Page 95, Your Lordship, is the deed dated 9th of October 2013.
Ninth October 2013.
2013. This is after. Lordship, may I show Your Lordship the schedule. Page 112. I could have understood Your Lordship that after 2012, they have changed Your Lordship the entire stand in selling those particular car parking spaces. Page 112.
Page 112 schedule.
Schedule. All that unit being office space number 5, measuring 642 square feet of the super built up area on the second floor of the building constructed at the said premises.
First schedule, you are reading all the.
Second schedule. First schedule, Your Lordship, is the entire area.
Yes, not required.
Yes.
Schedule.
Second schedule. All that unit being office space number 5, measuring 642 square feet of super built up area on the second floor of the building constructed at the said building and shown in red border in the plan A Annex A2, and together with one car parking space in the ground floor of the building. दे दो ना भाई, आपके पास है तो दे दो.
Yes.
So they have not changed it. Now, Your Lordship, whether I am entitled to get that car parking space in that particular area or not. Your Lordship, today I am not before Your Lordship.
Yes, that is not the.
Today I am before Your Lordship that they cannot convert those particular car parking space which are mandatory, Your Lordship, in the building. If I don't get, my remedies lies before the civil court. I'll go before the civil court. But what happened, Your Lordship, is deepest respect to my learned seniors, is trying to, Your Lordship, mix up, Your Lordship, the civil and the writ remedy. I have come before this honorable court that this car parking should not be converted into the office area at all. because the KMC Act as well as the building rules do not permit it. Now, Your Lordship, I have given, and thereafter, Your Lordship, all the deeds are, Lordship, I can show one by one, but those are all, Your Lordship, either post or pre, Your Lordship, orders passed. Immediately when they were doing, Your Lordship, at page 224, I made a representation. 7th May 2012, at page 224.
Yes.
So 7th May 2012, page 224, Your Lordship, I have made a representation, Your Lordship, saying, Your Lordship, this conversion of those particular car parking space into office area. Lordship, kindly sees. Page 226 at paragraph 4. My client has recently come to learn that Shashikant Khetan of 46 BB Ganguly Street, Kolkata, who is the developer of both Messrs. Excello Properties Limited, owner of the land, and Messrs. Saket Promoters Limited, developer of the said premises, is proposing to undertake work of the development on the ground floor of the said premises by seeking to construct thereon to convert the entire ground floor into shops and offices, whereas the said entire ground floor into shops, showroom and offices, where the said entire ground floor is sanctioned by the KMC for the purpose of car parking space as per the sanction plan video number such and such dated 6/7/2005, approved by Honorable Mayor dated 2nd of November 2007. So complaint, Your Lordship, was there in 2012, and therefore thereafter, Your Lordship, I have annexed, Your Lordship, all the representations till 2017. Because 2017, I rushed before this Honorable Court when they started, Your Lordship, the construction over the roof also. Then I immediately approached the Honorable Court, annexed the, Your Lordship, this particular, I obtained this particular order, and Your Lordship, I annexed the order with the writ petition, and Your Lordship, this particular writ petition, that order passed by passed regarding the conversion of the car parking space. There was no communication by the Kolkata Municipal Corporation. This is, Your Lordship, the more or less, Your Lordship, is the contents of the writ petition. I have shown, Your Lordship, the Ghanshyam Das judgment that clearly says regularization, Your Lordship, was not possible at that point of time. Kolkata Municipal Corporation did not have the power to do so. Now, Your Lordship, kindly take the affidavit in opposition given by the Kolkata Municipal Corporation. Once he was justifying, Your Lordship, the order only on the basis of the delay and nothing else. And the second one, they have admitted, Your Lordship, that there was an unauthorized construction, and as per the submission of the learned advocate for the KMC, they have passed an order. I don't know. There is no communication regarding that particular order. Your Lordship, kindly take, Your Lordship, the affidavit of the Calcutta Municipal Corporation, which has been communicated to me on 26th of February 2018.
Tell me the name of the advocate.
Yes, Your Lordship. Mr. H.S. Mondul. And Your Lordship, the affidavit has been affirmed by Ashish Kumar Ghosh. It has been affirmed on 19th February 2018.
Yes.
Lordship, the delay point, Your Lordship, the Calcutta Municipal Corporation has taken paragraph 4 at page 9. That I submit that the petitioners failed to make out any case for the purpose of interference by this Honorable Court in its res jurisdiction Thus, the said application is liable to be dismissed with cost. Apart from the above, the said application suffers from inordinate unexplained delay, inasmuch as in 2012, the petitioners admitted to have knowledge regarding the alleged violation, and only after the municipal authorities considered the issue and passed the order, the petitioner lodged the alleged complaint. Furthermore, the said application was not maintainable inasmuch as the alternative and effectuous remedy available to the municipal building tribunal. Now, Lordship kindly sees page number 10, subpara B. Pursuant to the above sanctioned plan, construction was made and subsequently it was found that certain violation has been done by the concerned person responsible in the car parking space by construction of masonry brick wall and converted the same into the other use. And accordingly, a demolition proceedings, being demolition case number such and such, was initiated under section 400 subsection 1 and 416 of the Kolkata Municipal Corporation Act 1980. The said demolition case was ultimately heard by the Deputy Chief Engineer, South, and upon hearing the said demolition case by an order dated 5th April 2012, the unauthorized construction and conversion was allowed to retain subject to compliances of certain preconditions as indicated in the order. That thereafter in 2015, also the KMC authorities detected some unauthorized construction on the roof at 4th floor, and accordingly stop work notice under section 401 of the KMC Act was issued on 1st of December 2015, and the intimation was also sent to the officer in charge of the local police station. Thereafter, an FIR has been lodged. That subsequently in the year 2018, upon receipt of the information, the KMC authorities inspected the premises and found certain unauthorized construction, and accordingly sought to initiate proceedings under section 400 of the Kolkata Municipal Corporation. Now, Your Lordship, kindly
Construction at the roof is still there.
Lordship, this that's my instruction, Your Lordship, that the partly constructed those particular pillars were there, but I don't know, Your Lordship, whether now they have been removed or not. May I just take instruction once? Lordship is there. Those particular pillars are still there. So, demolition order has not been till date executed. Lordship, kindly take page 12, paragraph 8, just 5 lines down from the top. I submit that the concerned department of the KMC itself detected the unauthorized construction and change of use made by the concerned person responsible, and thus initiated proceedings. An issue was heard by the Deputy Chief Engineer, Building South, and upon hearing by an order dated 5th April 2012, he allowed to retain the construction and change of use upon compliances of certain preconditions. At the relevant point of time, there was no objection from any corner. Now, Your Lordship, the question arises whether they have given any notice to me. Where the objection will come from the unit holders. Accordingly, the question of giving notice or personal hearing to any other person does not and cannot arise. After passing the above order by the Deputy Chief Engineer, Building South, on behalf of one Suresh Jindal, representation was submitted on 7th May 2012. It is noted that the petitioner kept silent over the issues and did not raise any objection, and as such, question of giving hearing to them does not and cannot arise. I have shown 2012, 2013, 14, 16, I was giving representations. Complete contrary, Your Lordship, stand they have taken in the affidavit in opposition. Further, the said application suffers from inordinate and unexplained delay and was not maintainable in respect of the issues which have been heard and settled. I deny, Your Lordship, there's a mere denial. And thereafter, Your Lordship, the reiteration of the same thing, Your Lordship, in the affidavit, nothing, Your Lordship, turns on that. So therefore, Your Lordship, there are two major grounds which the Calcutta Municipal Corporation has taken here.
Yes.
One is delay. Second, your lordship, the justification of their order. Third, your lordship, they said that there was no objection. And admission, your lordship, that they have not given me any notice. And the
Hearing was-
lastly,
Opportunity of hearing was not granted to me.
not granted. And we were there, your lordship, at that point of time. And the fourth one, that even if your lordship, there was a condition in the order dated 5th April that they will not violate or make any further unauthorized construction, they have done it in 2018. So even that particular condition or limitation of the order itself has been violated by this person. So whether this particular builder should be, your lordship, given any type of discretion, your lordship, after your lordship, that particular order has been passed. Habitual, your lordship, the person has a habit to make unauthorized construction, violate the laws which your lordship prevailing, your lordship, as per the Kolkata Municipal Corporation. Now the things very important. Now when the respondent number 5 and 6, your lordship, they filed an affidavit before this honorable court, whether they have disclosed that they have done any mortgage of this particular unauthorized construction. It's your lordship, when your lordship has actually passed an order directing them to disclose it, they said that no, their third party interest has been created. And what is the third party interest? It's not that, your lordship, that they have sold out that particular property to a third party. What they have done very cleverly, that somebody has taken a loan, that particular borrower, and he is a guarantor, executed, your lordship, a mortgage deed. I don't know, your lordship, how, your lordship, an equitable mortgage has been created, but ICICI Bank can be done anything. But they have done. I'll show your lordship their affidavit. Your lordship, kindly allow me to show the affidavit.
The affidavit which has been filed pursuant to the order passed by this court.
No, your lordship, this is the affidavit, your lordship, filed by 5 and 6, your lordship, as per the order passed by Justice Talukdar. And this was filed on 30th of November 2018.
Name of the
Advocate's name, your lordship, is mentioned. Onimesh Paul.
Affirmed on 30th November 2018.
Yes, your lordship.
Yes.
Lordship, this is the affidavit filed by them, and primarily objection, your lordship, in a nutshell, may I indicate?
This is affidavit in opposition.
Yes, your lordship. This is an affidavit in opposition filed by the respondent number 5 and 6.
Yes.
First of all, your lordship, in nutshell, may I just indicate the points which they have taken? They firstly started, your lordship, that there is no proper affirmation in the writ petition. I don't have any locus standi to challenge that there is an unauthorized construction. I don't have any right of audience before the conversion of the property. All flats were purchased after 5th of April 2012. No right over the car parking space. There is an alternative remedy before the building tribunal, and they have filed a suit. These are the more or less grounds, your lordship, they have taken. May I show your lordship, as Mr. Banerjee said, I'll show from the affidavit itself, page number 10. Lordship, kindly take.
Yes.
I say that the petition is supported by an affidavit of Abhishek Gadia, who claims himself to director of the petitioner and further claims to be the authorized by the petitioner number 1 to affirm the same. I say that in absence of the affirmation of the writ petition by petitioner number 2 to 10 and or their affidavit, the writ petition is not maintainable. So this is a lordship affirmation part. Now, lordship, kindly sees D. The petitioner cannot complain about the order of revision of the sanction plan by the municipal authority, since they have no locus to raise such complaint, and further since they are in no manner affected by the said order. So again, your lordship, this particular, your lordship, objection, your lordship, has no basis. I am your lordship, a unit holder in the same building. Now,
Even a stranger can raise objection.
even a neighbor can do it.
Legal construction. Yes.
It's not a cancellation of the building plan.
Yes.
Your Lordship kindly sees the order of revised sanction plan by the municipal authority is in accordance with the law. The same has been made by the respondent number 7 hearing chief engineer of the Kolkata Municipal Corporation, who is a lawful delegate of the municipal commissioner in respect of the powers under section 401 and 16 of the Kolkata Municipal Corporation Act 1980. It is settled law that no person other than the person allegedly responsible has any statutory right of audience before the municipal commissioner or his delegates in matter relating to the proceeding under section 400 subsection 1 of the Kolkata Municipal Corporation Act 1980. Since the Kolkata Municipal Corporation Act 1980 does not provide for any opportunity of hearing to the writ petitioner or persons similarly circumstances, and since the writ petitioners are no way affected by the order of the revised sanction pursuant to the retention and change of use, there cannot be any scope of the writ petitioner to contend that there has been any violation of principles of natural justice. In the facts situation, there has not been any non-compliance of the principles of natural justice by the municipal authorities in following statutory mandate by not giving the petitioner an opportunity of hearing in the matter relating to the revision of the sanction. Even otherwise, since there was no complaint before the sanctioning authority in the proceedings under section 400 subsection 1 of the Kolkata Municipal Corporation Act 1980, the question of any other person being heard in the said proceedings could not have been arisen. The petitioners have all purchased their respective flats in the premises long after the revised sanction in favor of the respondent number 6 has been granted on 5th April 2012. Complete false statement. There is, as such, in any event, no question of hearing the petitioner or any of them or any similarly circumstanced person or persons on the question of regularization of any alleged unauthorized construction or grant of any revised sanction. The petitioners and each of them have purchased their respective units in the building long after the issuance of the revised sanction plan on 5th April 2012. The petitioners have all purchased their respective units with open car parking space with eyes open, and in the process have acquiesced and or abandoned any objection they might have to the regularization of the ground floor. The petitioners and all of them have received their due entitlement under their respective agreements, conveyances, and upon such receipt of the same without any protest or demur, they do not have any further right to raise such issue regarding such revised sanction. The revised sanction being a public document, the petitioners are deemed to have knowledge therefrom at all material times. The effort on the part of the petitioner to reopen a closed issue after long 5 years having been received benefit under the same is illegal, bad, and seeks to malafide.
Therefore, my lord, we have taken the point of delay.
He said acquiescence, and the moment I give notice of objection, there is no acquiescence. The respondent number 6 is the person having, I'm sorry. power of the municipal corporation to allow regularization. In the instant case, the Deputy Engineer Building South, being a lawful delegate of the Municipal Commissioner under the Kolkata Municipal Corporation Act 1980, bona fide exercises discretion under Section 400, subsection 1 of the Kolkata Municipal Corporation Act, coupled with the power to permit changes of user conferred by Section 416 of the Kolkata Municipal Corporation Act in passing orders of revised post facto sanction. The State Director General specifically noticed that there is no complaint and that the deviations are not so grave or serious and infractions of the building rules are minor in nature. The State Director General accordingly placed an order of revision of sanction. The order passed by the Director General is within the jurisdiction and based on relevant materials on record. The Honorable Court under Article 226 of the Constitution would not interfere with the discretion exercised by the Director General, particularly at the instance of the writ petitioner who have no local standi and have not suffered any legal injury by the said order. Thereafter, your lordship, the P, your lordship, is not required. Same thing, your lordship, this reiteration of the legal provisions. Q, your lordship, he has mentioned that he has filed a suit. A suit being title suit number 1209 of 2013 has been filed by the respondent number 5 and 6 against some of the flat owners, including the petitioners 5, 7, and 9 before the 12th Bench City Civil Court at Calcutta. An order dated 13 September 2012 has been passed therein, restraining 13 has been passed therein, restraining inter alia the petitioner number 5, 7, and 9 from dismantling or demolishing the elevated car parking space. The said order has not been challenged by the petitioner in any superior forum. The elevated car parking space and the dispute in connection thereof, which has been sought to be brought to the notice of this court in the instant writ petition subject matter of the pending dispute before the civil court. Therefore, it is essentially a private dispute involving the disputed question of fact, which has been sought to be masqueraded.
Elevated car parking space is an issue.
Is also an issue, your lordship.
In the suit which has been instituted by the respondent number 5 and 6.
That's before the city civil court. And your lordship, that their allegation or the cause of action in the suit is some of the flat owners or the unit holders, they were trying to interfere with the working of those particular elevated car parking space. But before this honorable court, we have only two issues regarding, your lordship, the regularization and, your lordship, the unauthorized construction on the roof. And thereafter, your lordship, the same thing, your lordship, he has mentioned. In this particular affidavit, he has never said that there is a third party interest which has been created in favor of a third party or in the bank, because this particular affidavit has been filed in the year 2018. Now, when your lordship actually directed them to file a supplementary affidavit, your lordship kindly sees the contents of the affidavit, very short affidavit. Only, your lordship, paragraph 3 and 4, if your lordship kindly sees.
Supplementary affidavit.
Supplementary affidavit, which has been filed by the respondent number 5 and 6. Page number 7, your lordship, paragraph 3 and 4. I say that
Just a minute, just a minute.
yes, I'm sorry.
Paragraph 3 and 4.
Para 3 and 4. I say that Saket Infra Developers Private Limited, a group company of the respondent number 6, has obtained financial assistance from ICICI Bank Limited under a credit arrangement facility. So therefore, the respondent number 5 and 6 is not a borrower. Under the said facility, inter alia, the said converted office space at 39A Jurapukur Square, Kolkata 6, owned by respondent number 6, was offered as collateral security in the bank and accepted by them. Accordingly, a registered deed of mortgage dated 15 November 2017, the said office has been mortgaged by the respondent number 6 in favor of the ICICI Bank. And your lordship kindly sees the last 3 lines. I crave leave to produce and refer to a copy of the said registered deed of mortgage dated 15 November 2017 at the hearing of the writ petition if necessary.
Yes.
Your Lordship, what he has trying, para 4, Your Lordship, he has said that I say then in view of the perceived default in repayment of the loan and searching of interest, the ICICI Bank Limited has taken steps under section 13 subsection 4 of the SARFAESI Act. Inter alia, by taking over possession of the said space, the said office space has therefore in possession and occupation of the said ICICI Bank Limited. I am however not aware whether the bank has sold, transferred or dealt with the said property to and in favor of the other party by way of method of sale transfer prescribed under SARFAESI Act 2002 and the rules framed thereon. So therefore, hardly, Your Lordship, they have done a mortgage where they are not the borrowers.
And already the position has been taken by the bank.
Your Lordship, may I show Your Lordship what has happened?
Under section
It's
30
symbolic possession.
Code of Service Act.
Yes, it may have been, Your Lordship, taken as a symbolic possession, but no physical possession has been taken. The reason is the moment the notice has been pasted on the ground floor, we have given a notice and communicated the order passed by this honorable court regarding the status quo to ICICI Bank Limited. I have disclosed in my affidavit in opposition to the supplementary affidavit. Lordship, kindly cease.
In your affidavit in reply.
In my affidavit, yes, Your Lordship. Opposition to the supplementary affidavit. Your Lordship, kindly take page 18.
Status quo order was passed by Justice Talukdar.
Yes, Your Lordship. That is the order dated 24th of January 2018. Lordship, that order has, I have annexed, Your Lordship. May I just show the reply, Your Lordship, which we have given, or rather the letter?
Yes.
Page 18. Saket Owners Welfare Association to the authorized officer, ICICI Bank, Technopolis Building, Kolkata. Notice dated 16th December 2021 for possession of the property under section 13 subsection 4 of the Security and Reconstruction. Your Lordship, that's not required.
Yes.
Lordship, kindly see paragraph 2. We found a notice dated 16th December 2021 affixed on the ground floor of the building regarding possession of office space at the ground floor of the building at premises number 39A, Jodapukur Square Lane, Kolkata 6. In this regard, we would like to state that the owner of the land, Excello Properties Limited, together with the developer, have developed the G+3 commercial building at the said premises having 18 units, 6 units each at first, second and third floor of the building, and car parking space at the ground floor of the building. All the 18 units together with proportionate share of land with common areas and facilities and car parking spaces have been sold to the various unit holders by executing and registering necessary conveyance deeds from time to time. The landowners and the promoters have illegally converted the entire car parking space into the office space on the ground floor of the building. The matter is sub judice and is pending before the Calcutta High Court in writ petition number such and such. The court has ordered the parties to maintain the present status quo with regard to the property in issue until further orders. Copies are annexed. You are therefore requested not to take any further steps in connection with the sale, alienate or encumber or create any third party interest over the property in dispute till the final disposal of the writ petition. Otherwise, any further act on the part would be in violation of the order passed by the Honorable Calcutta High Court. And Your Lordship, I have also forwarded the copy of the order passed by this Honorable Court dated 24th January 2018. That is at page 20 and page 22. Your Lordship, this order of status quo has been mentioned, page 22, second last paragraph. Parties shall maintain the present status quo with regard to the property in issue until further orders.
During subsistence of the order of status quo, whether the ground floor can be mortgaged.
I'll address your lordship on that. I am armed with judgments. It can. These orders, these inter partes orders, will not stand as a complete freeze on every transaction, including statutory transactions. I've got judgments. Satisfy your lordship. I knew this point would come to your lordship's mind somewhere. I thought my learned friend would prompt this, but I knew this would come to the mind of the court. I'll satisfy your lordship.
Now, Your Lordship, two things are important. First, I had no knowledge regarding the order. No order has been communicated to me. Despite, Your Lordship, the representations have been given. What Your Lordship, the respondent number 5 and 6 are trying to do, Your Lordship, to fall this particular case into two exceptions. The exceptions, your lordship, in the writ petition, your lordship, is if there is an inordinate delay in approaching the court, and if there is any third party interest which has already been created, your lordship, in the property. Now, lordship, with deepest respect.
Any judgment, Mr. Sengupta, on the point that in view of Ghanashyam Das's judgment, the law is settled that retention order or regularization order cannot be passed. Now, if today the writ court in exercise of its jurisdiction under Article 226 does not interfere on the point of delay, then this illegality will remain in perpetuity. Any judgment on this?
Lordship, I could not get, your lordship, this type of orders, your lordship, where your lordship, the conversion has been, your lordship, the order of conversion has not been set aside by your lordship, the Honorable High Court. In despite, your lordship, that there is your lordship, the Ghanshyam Das's judgment or a third party interest has been created. So I could not get it, your lordship, but I got, your lordship, those line of judgments where the Honorable Supreme Court has also said, your lordship, time and again, that if there is an illegality, delay in approaching the court, or where the issues are, your lordship, the public in nature, then, your lordship, in that case, delay in approaching the court will not actually matters. The reason is, your lordship, I was not sitting tight over the matter. This is not a case, your lordship, where the corporation has given me the order. I was sitting over the order of the, despite notice, your lordship, from the Kolkata Municipal Corporation. I have taken no steps. And then, your lordship, after 5 years or 6 years or 7 years, I have approached this honorable court. All line of judgments, there are judgments against me, but all line of judgments are there that I was sitting over my rights. And during that particular period, a third party interest has been created. So writ court has not interfered with. But I could not get a single order, your lordship, where the order has not been communicated to me. Subsequently, I come before the court to challenge the order. And then, your lordship, the writ court has said that no, there is a delay. And your fundamental right to property under Article 300A, your lordship, will not be, your lordship, considered. Lordship, these are, your lordship, submission in the respect of factual part. Lordship, kindly give me 10 days on the next occasion, your lordship, 10 minutes. I'll show, your lordship, the judgments in connection with delay, whatever the judgments I could gather, and, your lordship, I'll conclude my submission.
That you have to address this court on the point of delay, relying upon the judgments.
Yes.
Before the commencement of submission by Mr. On behalf of respondent number 5 and 6.
Yes, your lordship. Before Mr. Banerjee starts, I'll take 10 minutes. I'll only give, your lordship, judgments to Mr. Banerjee and the honorable court and conclude my submission. Next.
And written notes.
Yes, your lordship, I'll give the written notes.
The matter is taken up for the matter is heard in presence of the learned advocates representing the petitioners, Kolkata Municipal Corporation, and respondent number 5 and 6. Mr. Sengupta, learned advocate representing the petitioners, has made submissions. Stop. Hearing of this matter stands adjourned till next Wednesday.
Your lordship, take it up this side, my lord. Kindly take it up Wednesday after the opening. We are fairly close, my lord, to the.
পরের সপ্তাহে তো একটাই তো সপ্তাহ আছে, তারপরে
দুটো আছে তোমার, একটা লাস্ট হয়েছে, একটা লাস্ট।
বুধবার এমনিতে
11th October.
11th October. I'll come back.
11th October 2022.
Next Wednesday, as you watch.
And Mr. Ghosh, I want you take an instruction that as I have already expressed my mind with that Mr. Banerjee has indicated, and it is part of the writ petition, that a plan was sanctioned in 2008. In the sanction plan, it appears that so far ground floor is concerned, the open car parking space are within the precincts of the construction of the ground floor. So there was, and just beside the ground floor, there is a park. There is a driveway, but there is no provision made as per the original sanction plan for open elevated car parking space. Now it appears that the provision has been made by respondent number 5 and 6, so that the unit holders can park their cars open elevated car parking space. Now, it appears that open elevated car parking space have been made by the respondent number 5 and 6 by the developers. So is there any permission granted for construction of open elevated or for providing open elevated car parking space? It is not there in the section. Yes. No, it's an elevation has been made. It's a device is there by which the elevated car parking can be the open space can be converted into a multi-layer car parking space. Which Mr. Banerjee is using the term MLC. MLC. Multi-level car parking. So, is there any sanction or permission granted by the Kolkata Municipal Corporation to convert the open space or driveway into MLCP? I am not passing any order, but I want an answer from you.
My lord, 11th, my
Yes.
learned friend will conclude. Kindly permit me to address your lordship after the vacation. Let him conclude. He has
10 minutes, 10 minutes.
he has some time. I'm making my humble prayer to your lordship. Let him conclude. I don't want to impede the progress of the matter. I'll come back immediately after the opening. I'm not kindly permit me, my lord, to put in, my lord, my rejoinder to their affidavit in opposition, because that contains some allegations against me regarding the mortgage.
This, last occasion also prayer was made, but I have not allowed the same.
Oh, lordship is,
Yes.
Oh.
Junior made this prayer. I have not
Achha.
allowed.
no, I'll tell you, lordship, why. There are certain assertions and allegations made in connection with the action of mortgage, which if I don't deny as a question of fact, it might come to
Not
hurt.
required at this stage. Let me hear you first. Let me hear you first.
I'm grateful.
So come back on next Wednesday.
Yes, sir. Great.
করে রাখা ছিল। সেট কি কোনো ইয়ে আছে, টাইম দেওয়া আছে? Yes.
My lord, in this matter, your lordship had been kind enough to give my clients an opportunity to tell each question of pay protection against counterparts. Your lordship had indicated that don't go by what has been paid wrongfully to somebody or erroneously. You say what your clients are. What are the dues of your clients? Your lord.
And your lordship said
No, not wrongfully. Whatever you can go.
Just a minute, let me go through my own order.
Order
Just a minute.
20th September.
Yes, just a minute.
No, I'll just pursuant to your
As
issued
I
order.
remember that you are seeking pay parity like that of respondent number 9.
Yes, yes. So I am on that. So your lordship
The
said
journey
you,
of respondent number 9 during the tenure was found to be different. So far, the
yes,
petitioner-
your lordship said you satisfy me. What is your dues? Now, regarding that, my clients had prepared a chart, but I find that it was prepared because he had to go through the service record. There are some complications in this. So I kindly give me one. This is not correct. They have to prepare a revised chart. I'll also relying on a circular of the corporation regarding pay protection. And I'll make this chart simple.
But Mr. Sen, your writ petition is based on
No,
the
no.
pay parity as it has been enjoyed by respondent number 9.
Yes, yes. This chart needs to be simplified, nothing else. I'll come back with a proper chart. Kindly give me 2 days. I'll make this chart.
Problem is the original side matters are taken up only.
I'll finish it. I'll not take
I
much.
was about.
Yes, your lordship will pass
the matter on last.
Yes, I know. There's some complication. I'll make it simpler. I'll not take more than 10 to 15 minutes. I'll finish my submission.
But all this I am submitting, my lord, that if, apart from the P parity, if it does not stand, that case which is made out in the petition,
I'll not make out
if he has a separate issue regarding the pay issue, then he can make it in his representation, stating all these facts, and that may be taken by the authorities.
No.
Then they can consider it.
But you kindly consider that chart and then pass the order. I'll be beseeching your lordship. Very
Very good, I
small
look
chart.
at it, but
I'll
the thing is,
simplify.
it is not to be going.
Keeping this aspect in mind, I have directed him
and
to make out an independent
case.
case.
Therefore, an independent issue could be made
to enjoy certain financial benefits or benefits related.
Yes,
to
but if he could say that,
but that may not be akin to the pay which was enjoyed by respondent number 9, since
Right.
respondent number 9 in the middle was appointed in a different post. So that's why then Mr. Sen said that very well, I will try to demonstrate this, that
yes, how they are entitled.
If it is demonstrated before this court that independently petitioners are entitled, then straightway this court cannot pass any order. Court has to give a
yes,
direction.
right. Well, that is happening, my lord. That can be looked into.
I'll make this chart simpler. I will not waste lordship's time. I'll take 15 to 20 minutes, 15 minutes maximum. I'll finish my submission.
দুদিনের মধ্যে আমাকে দিয়ে দেও, আমাদের দিয়ে দেও কপি।
On 18th October.
Very well. Well, I'll finish. I'll giving an undertaking. I'll finish it.
18th October.
Yes.
Or better, let it be on 11th.
11, yes,
if
yes.
it is after
11.
this matter.
Yes. 11.
Yes, Mr. Dev. Let it be on 11th.
Yes.
If it is not taken on, taken up on
11th,
11th, due to any reasons, then on 18th.
Mr. They say that earlier to Gobeshwar, it will be placed so that it could be completed by within a short time.
No, I whatever your
Let it
lordship
remain in
is,
the
yes.
At the time of call, Mr. Sen, learned counsel representing the petitioners has prayed for accommodation, which is not seriously opposed by the learned advocate representing Kolkata Municipal Corporation. Stop. Hearing of this writ petition stands adjourned till Wednesday next, 11th October 2023.
Grateful.
দুটো matter হবে, যেহেতু
Item number 32 from appellate side, Delhi cause list.
Lord sir, I am for the municipal, Lord sir, 32.
at the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, Rajpur Sonarpur municipality is represented by learned advocate. Stop. Same situation prevailed on 22nd September 2023. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order if any stands vacated. Urgent Xerox survey copy. Next. Application, add করে দেবে application, comma, if any pending also stands dismissed. কি application দেখি? Dismiss করতে পারে কবে না? Order. Next.
Item number 34. Item number
33.
33.
I appear for the petition in this.
Lord sir, I am for the
Nothing remains in
municipal,
this
Lord
matter
sir.
because the subsequent, there was a writ petition filed wherein your lordship has passed an order. This has merged with that writ petition because this was on the basis of an inaction. The inaction, municipality was not passing an order sanctioning our plan. Subsequent to file,
Hospital.
yes, hospital. Subsequent to filing of this writ petition, my lord,
Railway land was there. in
the
front
railway
of the
property.
hospital.
But subsequent to filing of this writ petition, they had passed an order that was challenged and that was heard by your lordship. So it has merged with
The order which was passed and another writ petition.
another writ, subsequent.
Whether the municipality has passed
Yes.
an order.
Yes, this was for the inaction. Once this was filed, subsequently they passed an order which was again challenged by a separate petition that was heard by your lordship.
That order has been pursuant to the order passed by this court, and order has been passed by the municipal.
No, no.
This is lordship.
What was the direction given by this court on this writ? on that
lordship,
writ petition?
In terms of the lordship's order, this is the order, my lord. We have applied before the railway authority also. We have not preferred an appeal. We have applied before the railway authority.
It's your right to prefer an appeal if you are agree. Doesn't matter.
This application is infractuous, lordship. Instantly.
So,
You are making everything infractuous.
No.
So far, this matter is.
No,
concerned.
we assured him
Find
that
this
the
writ
hospital
petition
is
that
made. If
municipality
treatment
has
will
not
be free.
passed the visit order.
Treatment will be free, and that I have assured him if the hospital is made.
He's praying that I should.
That will not be a fair deal. Oh, কালকেরটা? Now you have prayed for
In terms of this order, Lordship will pass.
permission from the railway authorities.
Yes, we have applied before the railway authority.
Unless and until that
And
is granted.
there were three conditions. Yes, and so we have already applied before the railway authority, that is pending before them.
So in view of this order, nothing.
In view of this order, this has merged into.
This application become infectious. They have filed that application that municipal is not passing the reason order. The reason order passed, that was challenged. That order has already been passed.
Twice. The writ petition which I have disposed of, it is the second writ petition.
Second, thereafter, after passing the reason order by the municipality. At this distribution, that municipality has not passed the reason order.
Did not pass reasoned order
Reasoned
at
order.
the material point of
At
view.
the material point of view. Subsequently, reason order was passed after filing this writ petition.
মার্চ করে গেছে তো।
March না, এটা infectious.
Issue. The present writ petition has been instituted as it has been submitted by the learned advocates representing the petitioner and the concerned Rajpur Sonarpur municipality. Say list of bolo. Advocates, comma, due to inaction on the part of the concerned authority of the said municipality to pass appropriate order permitting the petitioner to construct a building in order to house a hospital, HOUSE, verb, in order to house a hospital. Stop. It has been submitted that subsequently an order was passed by the concerned authority of the municipality
After filing of this,
which was put under challenge by instituting another writ petition being WPA 25533 of 2014.
Yes.
Stop. The said writ petition being WPA 25533 of 2014 was disposed of by this court video order dated 4th May 2013. Stop. Next paragraph. The learned advocate representing the petitioner submits that meanwhile steps have been taken pursuant to the direction contained in the order dated 4th May 2023, passed in the writ petition being WPA 2533 of 2014. Stop. Next paragraph. In view of the order, the next paragraph, having considered the submissions made on behalf of the petitioner as well as the municipality, it appears that taking into consideration the order dated 4th May 2023, passed by this court on the writ petition being WPA 25533 of 2014, the present writ petition has become infructuous. So
Yes.
accordingly, the writ petition stands dismissed as infructuous. However, there shall be no orders to cost urgent xerox.
Grateful lords.
নিতে পারলে তো নাকি অ্যাকাউন্ট ওভার করলে
take back the orders.
এটা একটা জেরক্স করে ওকে দিয়ে দাও তো
জেরক্স কপি আছে তো
কপি আমরা চিনি Yes, call the common list.
Give obliged lords.
উনিশ থেকে তাই তো 18 17 100 না হ্যাঁ 117 এই তো বললাম
Item number 119 from appellate side, monthly cause list.
At the time of call, no one appears for the petitioner and no accommodation is spread for. Stop. Next paragraph lists the matter under the heading motion group 5 municipality for disposal on সৈকত শোনো সপ্তাহে সময় যাচ্ছে পরের দিকটার নাম 11th October 2023. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 120.
$120 million. I appear for the respondent corporation, Bidhannagar Municipal Corporation.
At the time of call, no one appears for the petitioners and no accommodation is prayed for. However, Bidhannagar Municipal Corporation is represented by learned advocate. Next paragraph, it appears video order dated 10th September 2015. A coordinate bench directed the parties to exchange affidavit. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph. List the matter under the heading hearing group 5, municipality for disposal on 11th October 2023. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, confidential order shall be passed. Next.
Madam, led by Mr. Dondover.
Item number 122.
I beg to appear for the petitioner.
121. Item number 121. Nilima Ghosh. Yes. What about the issue which has been referred to the larger bench?
I'm told that it has been decided, my lord.
Is, my lord, with regard to family pension of the employee who, my lord, retired or died prior to 1981. Now, my lord, the issue has already decided, your lordship.
Family pension, but what about the pension in favor of the unmarried daughter?
Yes, paragraph 19, the answer is there. Your lordship, please look paragraph 19. Therefore, we answer the reference to this extent that the benefit of family pension can be extended to unmarried stroke.
Just.
My lord.
ঠিক আছে।
Yes. Lord, in this matter, my lord, several memoranda of the school education department have been considered. Kindly, my lord, I've taken the date. Kindly allow me to go through the judgment because whether those, my lord, that ratio will apply here also because it is under urban development and municipal affairs department. And that relates to, so I'll have to go through the memoranda because certain memoranda have been considered to come to the finding that.
But the municipality has already, my lord, forwarded my case
We
with
had
the local
forwarded,
bodies.
and the government has regretted that it is not applicable. So the applicability of the judgment vis-a-vis the municipality has to be considered. I'll just not check up and the state may be given a notice. State can notice this or notice the state. State tak number respondent.
That is in case of teachers.
Teachers.
Because not he has rightly pointed out, we forwarded it to the state government. State government regretted in 2012 itself, my lord. It was regretted by saying that no, it is not applicable. So let the state appear because ultimately sanction has to be given by the state and the fund will also have to come from the state. And they have specifically regretted in this case in 2012. The first page is the regret by the state, and the next page is the forwarding by the municipality. সেটা দেখতে হবে। মেনশন করবে এটা ইন্টারপ্রিট করবে যে এটার আগে ইন্টারপ্রিট করে করেছে সেটা করে তাদের এডুকেশন তাহলে সাধারণত করতে হবে।
The conditions of service of teachers are not akin to the conditions of service of an employee working in a municipality.
Yes,
How
there is.
straightway this will be applicable? My lord, then your lordship, please have a look the paragraph 19, the answer
I
of
was under the impression that in case of the municipality
No,
employees,
no, no.
this order was passed. No.
No, this one in respect of the education.
Of the order by this passed by the judgment delivered by the special bench, it does not appear.
No.
It was in case of DCRB scheme of 1981.
Yes.
Which was introduced with a notification dated 15 March 1985. Now, this 15 March 1985 DCRB scheme is applicable in case of employees of municipalities.
My lord, to the employees of the
Answer the query of this court whether the DCRB scheme of 1981, which was promulgated with a notification dated 15 March 1985,
yes, yes,
applicable in case of employees
yes,
of the
yes, of the municipality
Let us
also.
see, produce the DCRB scheme of 1981 for whom it was introduced.
Right now, DCRB scheme not with me, my lord.
Then
It will applicable to the all employees of the government and government undertakings.
it was meant for the teachers and non-teaching staff working in non-government aided institutions, not for municipalities.
My lord, 1981 scheme, my lord, for the government employees.
Issue. Why you are saying yes without knowing? You should have submitted that yes, let me go through the same and come back.
My lord,
You could have, why you are saying that it is applicable?
no, applicable, my
You are
lord.
doing this kind of this type of matters for a long period of time and you are making this irresponsible submission.
No, 1981 scheme, death come retirement benefit scheme.
It was for the teachers of the non-government aided teaching and non-teaching staff. Go through the notification dated 15th March 1985.
My lord. Kindly adjourn, my lord, I will go through.
The writ petition is heard in presence of the learned advocates representing the petitioner. Petitioner and Bali. You are for the for Bali municipality.
I'm for Bali municipality.
Bali municipality. Stop. Petitioner is an unmarried daughter. Stop. Next paragraph. The petitioner is unmarried daughter of an employee of Bali municipality who is seeking family pension due to death of the due to death of her father, who died prior to 1st of April 1981.
No, superannuated.
Who superannuated prior to 1st of April 1981. Stop. According to the next paragraph, according to the petitioner, in view of the judgment dated 20th June 2023, delivered by the special bench, petition and the observations made in paragraph 19 of the said judgment, petitioner is entitled to receive family pension. Stop. Next paragraph, Mr. Oyun Banerjee, learned advocate representing the municipality, has contended that DCRB scheme of 1981 is applicable in case of teachers and non-teaching employees working in non-government aided secondary schools, and the said scheme may not be applicable in case of the employees of the municipalities and local bodies. Therefore, according to the learned advocate representing the municipality, straightway the judgment dated 20th June 2023 may not apply in the present case. Stop. Next paragraph. Considering the issue involved in this writ petition, this court finds that representation on behalf of the state respondents is necessary. Stop. Next paragraph. The learned advocate for the petitioner is directed to serve notice upon the learned government leader in order to ensure representation on behalf of the state respondents on the next date. Stop. Let a notice let notice enclosing copy of the order and the copy of the writ petition be served upon the learned government leader by October 2023. By 9th October 2023 and file and an affidavit of service to be filed on the next date. Stop. List the matter for further consideration under the same heading.
on October 2022 for further consideration. Under the heading. Yes, you take it back. You take it back and produce it on the next day. Right. Oh. Under the heading hearing group 5 municipality for disposal. Check it. Well, sir. Next,
Item number 122.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph lists the matter under the heading motion group 5 municipality for disposal on 11th October 2023. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
One 123.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph, it appears video order dated 16 November 2015, a coordinate being directed the parties to exchange affidavit. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph lists the matter under the heading hearing group 5 municipality for disposal on 11th October 2023, stop. However, it is made clearly from the urgent date, petitioner goes unrepresented, consequential order shall be passed. Next. 124.
I appear for the petitioner, my lord. Your my lord, I had made a complaint to the municipal corporation, my lord, that the adjacent premises, they were making some illegal constructions, my lord, with the support of my premises. 2015, I filed a writ petition, orders passed, inspection carried out, and lastly, I think Lordship will find there's an order in your Lordship's, there's a report filed, my lord, by the municipality. Kindly, my lord, take the report. Dated 29th of July 2016. Kindly, my lord, go through the report. Lordship will find that there's a clear finding
Yes. Is there any private respondent?
Yes, my lord. No, except
Sub notice and come back.
because from 2016, no exception taken.
So your grievances against the private respondent. He has made the
Yes, but yes, your lordship is right.
Sir, notice and Mr. Mitra and come back. Issue.
Content.
The writ petition is taken up for consideration in presence of the learned advocates representing the petitioner and Kolkata Municipal Corporation. However, respondent number 5 is not represented today. Stop. The next paragraph, the learned advocate for the petitioner is directed to serve notice upon the respondent number 5 for the learned advocate representing the said respondent, enclosing copy of the order passed by this court today by
I'll serve it, my lord, by day after tomorrow. Matter can be taken up on Monday, subject to your lordship's convenience, my lord.
by 9th October 2023 and file affidavit of service on the urgent date. Stop. List the matter for further consideration under the heading. Was there any direction for affidavits?
Yeah, they've filed. They've filed affidavit.
Affidavits have
Yes,
been
yes, yes,
exchanged.
yes. My lord, I have not filed a reply.
List the matter under the heading hearing for disposal on 11th October 2023 for
Grateful,
further consideration.
grateful, my lord. Lord, may I make one prayer for indulgence? Can it appear in the daily list, my lord?
It is on.
Yeah, in the day. I'm very.
11th October.
I'm very grateful. Very.
Yes.